You didn't print it on the A4 white sheet. Wasn't it supposed to be on A4 white sheet? We need to. He usually is pretty legal because this thing is only this usually
ಬೀರು ಇಟ್ಟು ಫೈಲ್ ಅದು ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಆಮೇಲೆ ನಾನು ಫೋಟೋ ಇಡಕ್ ಬಂದಾಗ ಇದು ನನ್ನ ಫೈಲ್ ಯಾವ್ದು ಯಾವ ಫೈಲ್ ಇದೆ కదా ನೋಡಿದ್ರೆ ಇವತ್ತು ಡೇಟ್ ಇದೆ ರಿಪೀಟ್ ಕೊಟ್ಟೆ ಅದನ್ನೇ ಅಬ್ಜೆಕ್ಷನ್ ನಾಳೆ ಫೈಲ್ ಮಾಡಕ್ ಹೇಳಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಯಾವ್ದೋ ಹೇಳಿದ್ಲೆಲ್ಲ ಅವ್ರು ಯಾವ್ದೋ ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ ತಪ್ಪು ಮಾಡಿದೆ ಅಂತ
What officer?
ಸರ್ ಹೇಳಿ.
ಇನ್ನೂ ಸಿಟ್ಟಿಂಗ್ ಲೇಟಾ ಮೇಡಮ್?
ಇಲ್ಲ ಬರ್ತಾರೆ ಸರ್.
ಓಕೆ.
ಮೇಘ ಬರ್ತಾರ ಹೇಳಿ. ಮೇಘ ಬಂದಿಲ್ಲ ಅವ್ರೇನ ನೋಡಿ ಅವರಾದ್ರೆ ಪರವಾಗಿಲ್ಲ.
this baby wasn't very strong.
With Megan, I thought
I don't want to believe it. What a shit because they did it. Good amount. One big tamasha happens. We leave it. Someone to take it up on BC is what I mean.
Yeah, no, yes, to 20. ಎರಡು ಇದೆ ಇನ್ನೇನು ಇದೆ ಇಲ್ಲಿ ನೋಡು 29ಕ್ಕೆ 15 ಮೀಟರ್ ಇದೆ ಡೇಟ್ ಗಿವನ್ ಅಲ್ಲ ಅದು ಸಿಪಿಸಿ ಅದು ಅದಕ್ಕೆ 30ನೇ ತಾರೀಕು
Now see why I'm asking you for a reason because 23rd, the Delhi High Court matter is also before it is Come here.
What's in this matter, your lordship is intervening in the chambers and the chamber hearing is happening and the next date is on 12/8. However, for some reason, the mother is not sending the child with the father. So I just wanted to move this matter to next week, Wednesday. It's been more than 3 weeks. The child has not seen the father.
Lordship, in this matter, it's custody matter. The minor son is residing in Guwahati. That's where he's ordinarily residing. Now, the trial court in Bangalore has ordered for his physical presence on Saturday, Your Lordship, without having any jurisdiction. So I request Your Lordship, it may be kindly taken up either at the end of the list or tomorrow, depending on the convenience of the court. Obliged.
Tomorrow.
My lords, this matter was listed before my lords on 12th and it was ordered to be listed today. It doesn't feature in the list today, my lords.
Monday.
Lords, is it possible for tomorrow? I may request it for tomorrow, my lords.
There's so many matters.
My lords, in this matter, with that Niman's report and all with whatever the entire story that unfolded on the last occasion, the visitation has not transpired post that for them because the last visit.
What was observed on the last occasion of the matter came?
My lords, if my lords may recollect, we had given a set of proofs where he, as per the court's direction, when he went, they were to file an affidavit which has not yet been served upon him.
So I think because I know it's coming up finally to pass orders, let it come on Monday and pass orders. Because there's nothing like no.
I may be permitted to appear on VC in that case, my lord, because I may not be.
You can appear, there is no permission. Yes.
Material number 34, I'm going to withdraw it, my lordship.
Page wise,
34,
34.
become infectious. Challenge the orders on IA. Main matter is disposal. Filing memo.
Krishna BJ.
Serial number 38, my lords. I'm filing the memo of withdrawal, my lords.
Serial number?
Yes. 38, my lords. Serial number 38. The writ petition is having become infectious, my lords.
Yes, Mitchell. Page number 1, parted matter, serial number 1.
Respondent.
But on the last occasion,
I appear for the response.
they took time to clarify a lot because the survey number mentioned in the original decree and there was a change in the survey number in the execution law. Original survey number was
126.
126. In the execution petition, the number was, I'll just,
807.
807. And the revenue authorities had indicated that this 807 is not falling part of the original number and it is overlapping with my number. That issue was raised before the executing court. Executing court did not just refer to those documents, but did not render a finding. On that point, Lord, your lordships, they had.
My lords, I permit my lords, move with my lords, few documents. My lords. This were part of a record, sir. Notes first contention, my lord, they cannot maintain writ petition, my lords, is a final order against the execution order, my lords. One submission.
Let's see the order. There are two petitions.
Of, my lord, second one, 58119 of 2018. It's a final order. Yes, my lord, disposal, my lord. Impute order, page 100, my lords, and operative portion of it.
Various or related.
Yes. Yes, final disposal of the execution.
So according to you, what is the remedy available?
Is my lords in either in CRP or my lords in RFM? CRP or in RFM?
CRP?
Civil revision petition. No, my lord, this is writ petition.
27. It's a revision of the order of the court, though whatever name you take, it is a revision. And a 227 writ petition, or here you call it a writ petition. Otherwise, it's called CRP.
Yes, my lord, so there's a civil revision petition under my lords and the CPC, my lord, they have to.
Think so.
Please, my lord.
Now, all what 227 petitions you call here, in Andhra and Telangana, it is CRP. We call it a CRP. There is nothing like a writ petition at 227. It is a CRP and 115 or a CRP and 227. Yes. So what this court is, the jurisdiction this court is, it's a revision. We are revising the order of the court below.
Lords, it's under 115 of CPC, my lords.
115 of CPC, it be a case where it's nothing is pending before the court below.
Nothing is pending before the court. After disposal of this.
Then you have what are those called? For that, if something is pending, it is 227. If nothing is pending, you file a CRP and one.
Yes.
I was thinking
Now-
that is also is a writ petition.
No, so that's where they either they have to exercise the power under that my lords 115 because in view of.
So no, there is nothing pending through the court.
No, my lords. Now, my lords, coming to my lords, their statement of objection today, I have filed a memo, my lords. The last time my lords have asked, sir, what is the statement of objection filed in execution proceeding by my lord? Right.
Yes.
Page 1, my lords. It is not their case, my lord, there is disputing the identification of survey number accounts. Not even a single whisper made in the statement of objection. Please, my lord. The execution petition filed by the decree holder is not maintained either law or facts. Against the judgment and decree passed in OS number 223 of 97 and RA 115 of 06, judgment debtor have filed appeal before the Honorable High Court of Karnataka. And knowing this, decree holder has purposefully filed the present execution case to cause untold hardship, inconvenience and injustice and to coerce the judgment debtor yield to the unjust terms of the decree holder. When the judgment debtors have already preferred appeal against the judgment and decree passed in OS number 223 of 97 and RA 115 of 2006, the present execution case liable to be stayed as per order 21 rule 26 of CPC. The decree in question cannot be executed in terms of order 21 rule 11 of CPC. The decree holder himself has admitted in his execution petition itself that an appeal has been filed against the decree and therefore the execution is liable to be stayed. Order 21 rule 26 of CPC. The execution petition is vague sides false. The execution petition filed by decree holder is false, frivolous, vexatious, and mischievous in nature. The execution petition filed by the decree holder is divided. Therefore, the judgment debtors humbly praise this honorable court to reject the execution.
Yes. So according to you, such a stand is not taken.
Not taken.
What has been.
Yes. Now, my lords, to say overlap his land, he should own a land there. He's not a owner of the land itself. There is no land adjacent to it. Kindly see second document, my lords. In my suit, my lord, there was some liberty in RSA to proceed by filing a title suit. Against that, my lords, he files a title suit. Wherein, my lords, I have produced a judgment copy. A page number 5, my lords, and the brief facts of the plaintiff case. That is his case, my lords, is narrated. The plaintiff is the absolute owner in actual physical possession of enjoyment of a scheduled property, having acquired the same under register sale deed dated 5/7/1984. The plaintiff had applied for the grant of 4 acres 20 guntas of land in survey number 126 of G. Agrahara village. Accordingly, the revenue authorities recommended for the grant of 3 acres of land in favor of plaintiff, and the said grant has been approved by the Telecast Advisor Committee in the proceeding of its meeting held on 14/6/1984. But no Sagwal sheet was issued in favor of the plaintiff yet. However, the plaintiff is in possession of 4 acre 20 guntas of land in survey number 126, which is described as a B schedule property. Likewise, the plaintiff has encroached an extent of 4 acres of land, government land in survey number 126 of Agrahara village, much prior to 1984, and is in possession and enjoyment of state land, also which is described as a C schedule property. The fourth defendant got a portion of land, that is myself, my lord. My name. Portion of land in survey number 126 from the concerned authority. By suppressing the material fact and grant order dated 39/1984, on the basis of said grant order, he filed a suit for permanent injunction in OS number 223 of 97 against the plaintiff and others, and obtained a decree in his favor. The said judgment was challenged by the plaintiff in RA number 115 of 2006, but the said appeal came to be dismissed, against which the second appeal was preferred before the Honorable High Court of Karnataka in RA. So the said appeal also came to be dismissed with observation that if the applicant therein dispute the title of the suit property, the appellant are at liberty to file a separate suit claiming appropriate relief, and observation made in the said second appeal shall not come in way of the trial court in dealing with such suit. Hence, the plaintiff has come up with this suit claiming the aforesaid reliefs. Upon service of suit summons, the defendant number 123 appeared before this court through learned DGP, but did not choose to file returns. My lord, section survey number 807 is referred there. That, my lord, does not challenge that. Now, my lord, the suit has been dismissed, holding that he is not in adverse possession. Please, my lord. This judgment was passed on, my lord, 6/8/2014. 2014. Further appeal RA was filed, my lords. The judgment and decree is confirmed. That is, my lords, a decree at page number 29, my lords, and judgment at page number 35. 20th February 2018.
20th February
2018.
This order in the EP?
This order has been passed on 2018, my lords. That is on 21st December 2018.
After the dismissal of the.
Yes. And, my lords, what annexes my learned friends want to rely upon pertain to correspondence made during the 16 and 17 and 18. Those who are not, my lords, not brought in appeal in RA 75 2014, if that is so, my lords. Now, my lords, if, my lords, there is any challenge to, my lords, PODI related issues, the remedy available before the, my lords, under section 49 before, my lords, joint director. Now, my lords, they cannot contend. So far as the decree is concerned, my lords, the boundaries are specified, survey numbers are there, my lords. In fact, this survey number is not being disputed that it has turned 126, turned to, my lords, 807. In absence of right, my lords, and interference, my lord, therefore the trial court held that, my lords, and passed in a impugned order, my lords. Therefore, my lord, there's absolutely no ground for interference for the trial court, my lords, is my respectful support.
Yes. Lord, first of all, on the point of maintainability, my lord, this order, page 101, my lord, it says keeps the execution pending. It is not a final order. It says at 102, issue arrest warrant against JDRs by 18/1/19. Next date is fixed as 18/1/19. The case is 2112. The signature of the learned presiding officer is 21/12/2018. So therefore, execution is pending, not it is going on. It's not a final order. The only remedy is revisionary jurisdiction under 227, where the Honorable High Court has supervisory jurisdiction over all the tribunals and courts in India. This is the first. Now, not so far as second issue is concerned, it is not in dispute between the parties. That Nandu.
When the
Grant.
comprehensive suit for declaration, court has given a finding that he couldn't even establish that you are in possession of the property.
Correct. Not so far as the schedule there. So far as the schedule there, the court has given a conclusion. What has happened, Lord? On the point as to whether I had been granted a land or not along with them, kindly see document number annexure A, Lord, of the translation. Yes,
By the competent,
yes,
court, in the petition filed by you, in the suit filed by you.
yes,
No, and when it is confirmed in RA,
yes,
how can this court can look into any other document than the judgment and decree?
yes, Lord. I'll just point out this annexure A, page 1. Document on material facts.
Page number?
Page number 1, translation. Learned friend has given these documents just now, Lord. While he was about to start arguments, we had no opportunity.
Bracket it will hear
Yes,
it.
at least,
Let him-
at least
Have
because,
the advantage of looking at,
yes, because it was given just now.
was the smarter Monday
Yes, please,
at the request of the counsel for the petitioner,
please,
same under the same caption on the top of the list.
please.
Yes.
Stay may be extended. It has been
What-
extended.
They did not choose to extend last 4 occasions.
Let's see that. Let's see the.
I think
doc-
last occasion,
No, no.
No, arrest warrant in second matter,
arrest warrant, no, at least.
in second matter.
In this matter, it is not there.
Yes, no.
In the first matter,
No,
Lord.
no, second matter,
No, in,
1.1.
1.1, Lord.
what is that?
Change personal community. Which is the out date.
Okay.
Interim order was granted on 31/1/2023. Interim order granted earlier shall stand extended in the next date of hearing. Thereafter, in right from
Choose to extend.
22/2024,
Yes.
the interim order is not extended.
I requested, I
4/6/2024,
Notes, I have-
it is not extended. 18/6/2024, it's not extended.
Arrest warrant to the state.
27/6/2024, it is listed, not extended. 3/7/2024, not extended. 9/7/2024, it's not extended.
No, my lord, I mentioned, my lord, in
Since it
every.
is
Not about this court, Mr.
Please.
Counsel.
Please.
It has come up before other learned judge on 12/2/2024. Even on that day also, it is not
So I
extended.
mentioned, only arrest warrants have been
The
stayed.
adjournment
Unfortunately,
on
what has
condition-
not been done,
State hearing.
no, it can't be done.
But anyway, next date of hearing, your lordships will be deciding. the matter.
Yes.
Lord, can it
Finally,
be,
we'll be deciding it on Monday.
but can it be on Tuesday, Monday?
Tuesday. Yes.
Monday.
Next matter.
Still number 2. Still number 2 is appearing for the petitioners, my lord, file necessary application to implead the deceased respondent number 1, R1 is legal heirs. As per the application given, notice
Where
has
is
to
the
be issued.
application?
Applications were filed, my lords, on 12th of July.
The IA number 3/2024 is filed. I number 1, 2, and 3 are filed to condone the delay, to set aside the amendment and to bring the LRs on record. Issue notice in I number 3/2024. Pose this matter on,
My lords, the second case, I'm producing a memo showing the details of all the respondents, whoever has been served. The last time, the second case, R1B to C,
One minute.
notices.
first let us complete this. Accordingly, the issue notice pose this matter on August 5th. Yes, what is the next matter?
Still number 2, there are 2 matters.
That's for 2.1, what is it?
This 53588, this is another interim application. In that R1B to C, my lords, it is asking for notice for the 4th time to be reissued. Last time it has been returned as unclaimed. So that may be. if
Where
the
is that?
order-
Is it mentioned in the cause list?
3rd time it was mentioned in the cause list. Now they're asked, the today's cause list, they're saying for reissuance of notice for the 4th time.
This court officer, look at this. Unclaimed in respect of whom?
Unclaimed in respect of R
For the postal
B,
shara, notice. sent to-
R1B. B,
at that.
C. B and C.
Look at this. Let the officer put up a note with regard to the service of notice on all the respondents. Post this matter tomorrow.
My lord, in this matter also I have filed necessary application. This
Just
matter.
want to
also-
look at it, who are not served and what it is, then we'll, that application will order tomorrow. Yes.
Cell number 3. HR Ananta Krishnamurthy illa illa.
Annexure piece and challenge. The lordship turn to the next area. At page number 47 commences and the relevant order is at page number 51.
Where is IA?
IA. I will also turn to page number
No, no, this order or impleading so and so is not ordered.
44.
No, it is what application which is rejected. To implead the party, for that a separate application is filed before this court.
How can it be?
Can't be.
No, no.
No, they want to argue on the
No,
merit.
no. That in respect of that, because the LRs have been for different 5 days during the pendency of the month. He handed
First,
over
let us
he handed
see.
over the case.
What is the order impugned in this?
That's what I'm.
Page
Your lordship
51.
turn to page number 51, madam.
51.
Yes,
Hmm.
IA 19 and order 22 rule
Order
4.
22, rule 4,
Yes,
on 51 CPC.
yes. May I read out?
No, this is dismissed. This IA is dismissed.
Yes.
Now, what is this IA before the court?
Because the trial court failed to.
Once again, take
Allow
back
the-
your-
Under order 110(2), we have had to issue LRF regarding the impleading application. Notice is to be ordered. Because even in the objection, paramount your lordship turn to page number 44.
So the whole crux of the dispute
Yes.
is whether she is a LR, whether she can be pleaded as an LR of the deceased defendant.
Paramount your lordship.
So 1 minute,
Yes.
that is the dispute.
Yes, yes.
Then you have questioned it before this court.
Yes.
No, this court will finally decide that. In the meantime, what is this order 1 rule 10 petition in a CRP, in this writ petition? Now, this has to be decided by this court.
Yes,
Finally.
yes.
Then in that case, when that is what is before this court, how can there be an impede petition for the same person who's in favor of whom the application is dismissed before this court?
No, your lordship, list it tomorrow. Man. Day after tomorrow.
No, it
No,
is
no,
very
even
strange.
Paramount your lordship, page number 44, she filed an objection. Paramount,
All that
very
could have been
44
done is,
Paramount your lordship, turn to page number 44.
We'll go into all that. The court will
Yes,
hear you.
yes.
Court will definitely
Yes,
hear
yes,
you.
yes.
Please, if you answer the court's query, then we'll go further.
Yes.
You have questioned a particular order that so-and-so is a legal representative according to you. He should be impleaded. Court said he cannot be in a suit for, in a right
Ejectment,
control matter.
Ejectment.
Then the court said he cannot be impleaded.
Yes.
You filed a revision here. In the revision, by way of an application under order 1 rule 10, you want that the very same person to be impleaded to this CRP. Where is the question of filing a order 1 rule 10 petition in a CRP? Because there are new proceedings, nothing
But-
here. It is a you are questioning an order that is rejecting your application.
IA
So
90.
how can
Yes.
somebody else be impleaded
No,
in this?
same person, madam.
I'm sorry, for this, no time can be granted. How can a person, please tell me on legally, nothing, no, not on this aspect. You questioned an order that so-and-so is not impleaded by the court. But once the court passes an order finally, court will pass an order saying that whether he is a legal representative or not. And when what you can't get it by way of an order from the court, which is questioned before this court, how can there be a order 1 rule 10 petition? It can't be. It can't be. There can't be any law like that. In every case now, an application will be filed before the court. Court dismisses it. You will come before it, questioning it, and you will also file a order 1 rule 10 petition to implead the very same party.
No, earlier, madam, because the very, in a WP writ petition number 1590/2007, there is an order, direction to these, including this Lalita, to deposit the amount. The respondent number, dependent number 5.
The
Is
court
that-
might have done, the court might have done, that is not law. That's not law. There is an impugned order, we have to decide whether such order is right or wrong.
Yes.
That is the only jurisdiction this court has got. This court has no other jurisdiction or no other orders can be passed. This is not a writ jurisdiction, just like that we call somebody to do something. It is under, we are exercising the jurisdiction under 227, and court has to be conscious enough
No, no.
to look at the impugned order. And please argue on the main petition. That can't be, that order 1 rule 10 won't, that can't be heard.
By hearing the main matter, you will also list it on Monday.
Huh?
By hearing the main matter, we will withdraw that IA also.
Please argue the main matter. Argue the main matter.
Possible Monday, madam.
IA number 1 is filed to implead the LRs of the respondent,
Dependent number 5.
Huh?
Dependent number 5.
defendant number 5, which application came to be dismissed by the court below, and which is pending before the, and again, is that the present writ petition is filed. An application under order 1 rule 10 cannot be entertained by this court. Accordingly, IA number so-and-so is dismissed. Pose this matter as is a writ petition of 2016 as the top of the list on Monday.
Cell number 4,
Yes.
Raj. Nagaraj Rao Gate.
You're for the respondent. Where is the petitioner?
Normally, he will skip away from the court and he's come normally skip away from the court and seek for a extension of interim orders. Problem is that once it was dismissed, it was dismissed, all the two petitions were dismissed. How it is stated for hearing on that IA, it is stay. In a FTP proceeding, I cannot take possession of a property. In public, it's a partition suit, co-sharers bid the action. And they successfully the auction. And they want to take possession of the property. As a ground floor is concerned, petitioners possession and possession. As first floor is concerned, this fellow is calling, petition is calling, handing over possession. And may I take your lordship to interim order?
1 minute.
Sorry.
Please come. This matter is coming up before the court, right from 6/6/2024. On 6/6/2024, at the request of petitioner, the matter is adjourned. Again, the same request is made on 11/6/2024. 13/6/2024 also, the similar request is made. 20/6/2024, again, a similar request is made, and the matter was directed to be listed on 4/7/2024. Again, on 4/7/2024, a request is made. Then the matter came up on 9/7. On that day also, on that day, at the request of the counsel, the respondent, the matter was directed to be listed on the top of the list. Then when an adjournment was sought on 10/7/2024, the matter was adjourned, the matter was directed to be listed on 11/7/2024. Whether the counsel is ready on that day or not, the matter would be heard. On 12/7/2024, the matter was again directed to be listed on 16/7/2024. Today, when the matter is called, there is no representation. This is a writ petition of 2017. And without having obtained an interim order, without even arguing the matter, time and again, the petitioner is seeking adjournments. Post this matter for dismissal on Monday at the top of the list.
Cell number 5.
That day we will pass orders on the merits of it without dismissing it for default.
Because they may again make an application for.
That's why we will we will pass an order on merits. We can't let the parties to take advantage of like this.
Interim order.
Yes.
So lordship may have it on top of the list.
No interim order will not be granted,
Right.
extended. Yes.
Especially with the lordship may say the interim order not extended, otherwise they will.
This court is not extending the interim order, considering the manner in which the petitions or the petitioner is seeking adjournments.
Top
Yes.
of the list. Sorry.
Top of the list. Cell number 5. Shri Hari K for petitioner.
I
IATA Shetty.
Beg
I
to
appeal for the
respond.
petitioner, my lords. That's the respondent number 3 is dead and we had filed LR applications, my lords. They have been served unrepresented, my lords. So I.
My lords, the
uh,
petition itself is rendered infructuous.
The other day you were saying, what
Yes.
is it?
My lords, the order that is in question, my lords, is an order that has been passed in a regular appeal. The impugned order, which my lords would find at page 80 onwards. This is RA number 46 of 2009. Now that regular appeal itself has been rejected, my lords, on the 15th of July, the last week,
15th of July.
2024. So therefore, my lords, the petition may not.
We'll record that. Please come. Today when the matter came up, learned counsel appearing for the respondent submits that the present writ petition arises after an order passed in RA number
46
For-
of 2009.
Please,
43 of
46 of 2009.
46 of 2009.
please.
And the RA itself was disposed of on 15th of July 2024. Considering the same, now now this IA do not stand for consideration, accordingly dismissed as infructuous.
I'm so grateful.
Obliged.
Yes.
Cell for dismissal, cell number 6. Vinayak. For petitioner.
No, this is yesterday's matter. Give that. Give that. This court has permitted the counsel for the petitioner to retire on 16/7/2024 and directed the registry to print the name of the party. It is stated by the counsel for the petitioner on 16/7/2024 that by email, there was instruction on 27/8/2021 itself not to appear on her behalf. And she has also made several imputations against the counsel, and certain defamatory statements are also made. The counsel has filed OS number 4881 of 2021 for recovery of the professional fees. In that, the party, the petitioner herein has filed the written statement and contesting the same. Hence, the court has permitted the counsel to retire. Now, right from 2021, when she is aware of the fact and that she has taken no objection from the earlier counsel, till now, the petitioner has not taken steps to engage any other counsel. In that view of the matter, this appears that the petitioner is not interested to pursue the matter. Accordingly, dismissed for non-prosecution.
Then number 7, preliminary hearing B group,
Petitioner.
AG Commerce for petitioner.
Undertaking to file the
Petitioner.
wakalat for the respondent, my lords.
This, we'll just hear them. What is the matter?
Copy may be served to me.
Hmm.
Copy. That is to the trial court, right?
Now you tell, what is the
Yeah.
impugned order?
Petitioner is the father, my lord.
Huh.
A GNWC case came to be filed before the trial court. IA number 1 was for restraining the child to be taken out of Bangalore. Incidentally, the cause title was both of them were staying in the same house, my lord. At the time of filing the GNWC, both of them were staying in the same house. IA number 1 was for restraining them from taking the child outside the jurisdiction of the court. For that, they file a memo before the trial court, and the trial court records the memo. May I request this honorable court to turn to page number 16, my lord. It is entered in the order sheet. Ink page number 16.
Yes.
The typed matter, my lord. Counsel for respondent files memo stating that the minor will not be removed from city as sought for by petitioner in IA number 1. Now, again, the same thing is reiterated at page number 17. First para, my lord. Last occasion, the learned counsel for respondent undertook not to remove the child from the parent's custody, father. Now, thereafter, 2 IAs were filed again during the period, not to remove the child and also for visitation rights. The honorable court has dismissed my application, IA number 2. Common orders were passed, restraining the child from to be taken out, and IA number 3, visitation rights were given. Now, looking into this, she has already she has gone out of this jurisdiction and she has gone to Delhi, my lord. She has taken the child without my permission and she has gone to Delhi. Then what happens to what is the undertaking that they have given? My specific plea before the trial court was that I seriously apprehended that she is likely to take.
Once an order is passed,
Yes,
why
ma'am.
do you want to test it again? This order,
Yes, my lord.
there was an undertaking that is on,
But there was a gap of 1 year, my lord, thereafter. The initial was,
whatever is a gap,
Yes,
when there is an undertaking before the court,
yes, ma'am.
unless and until she seeks the permission of the court.
Yes, ma'am.
She cannot take the
Yeah,
child.
but IA,
File that application. Is it not a self-goal?
no, IA 2 and 3.
Three you can ask.
Yes,
Three
ma'am.
you can ask.
Yeah, yeah.
Now, why should you file an application and get it dismissed when there is already an order in your favor?
At that particular point in time, she moved out of the house. For just last 15 days, she
You
moved
would
out.
have faced the consequences.
Yeah.
Instead of an IA,
Yeah, yeah.
you would have filed some other application. No, unnecessarily, no, she has edge for this, because no, the order is, court has dismissed her. Now I'll take the child to the out of the
No,
jurisdiction of the
precisely
court.
on the such dismiss only I am before this honorable court.
Yes.
For having dismissed,
Now, what is happening?
My lords, I'm only the proxy counsel. I don't have a copy of the petition as well. The copy was served to the trial court advocate. So we may be served a copy.
There is an order whereby now that application is, on what basis that application is dismissed? On what reasoning?
No, saying that order 39, rule 1 and 2 will not apply for these things. It's only for protection of child. So restrainment not possible. That is the opinion.
In that case also,
Yes, ma'am.
only your application on the maintainability of it is dismissed.
Yes, ma'am.
But that order earlier passed saying that like she will not take the child out of the
Yes,
the place,
Yes,
out of the jurisdiction, is still there on record.
Yes, my lord. That IA is still there because only under there
Not
is
the
no.
IA, that undertaking.
Yes, my lord. Still it's there. That's what I'm
Get
making.
instructions.
Yes, ma'am. Week's
Will
time
post this
notice.
matter and let the
Let the
mother,
child be kept present, my lord.
let the mother and the child be present before the court. The petitioner is agreed with the order of the court below, whereby the court had dismissed the application filed by the father to not to take the child. Restraining the mother from taking the child out of the jurisdiction of the court and for visitation rights. The court had allowed the application seeking visitation rights. When it comes to the order restraining the mother from taking the child from the jurisdiction of the court, court has observed that an application under order 39 is not maintainable. And counsel submits that earlier when the earlier when he has moved such an application before the court, the respondent has filed a memo that the minor will not be removed from the city as sought by the petitioner in IA number 1. In spite of all this, she had taken the child to Delhi, and now the order that is granted by the court, where you can exercise the visitation rights.
It's in Bangalore.
Where is that order? Let's see.
Page number 28, my lord. Ink page number 28. At the 5th line, my lord, the education of the child also has to be taken into consideration. Thus, the custody of the minor son is granted to the petitioner, most probably on Sunday and school holiday, that would meet the ends of justice. He is entitled.
He has the visitation rights on every Sunday from 8 AM to 10 PM.
And other school holidays.
And is also entitled to the interim custody on public holiday to the school, if any, of the said time.
My lord, the child, one submission. The child was already studying in Bangalore and I have already paid the fees of the school. Despite that, she has just taken the
Considering
child.
all this, the mother shall be present before the court along with the child on which date?
A week, next week, and days. Next week.
On 25th.
Much okay for that.
Till number 8. In BS for petitioner.
Waiting for the
Take
petitioner,
a
my lord. So I
copy.
seek for a password.
Yes, also.
Till number 9. Till number 9. Vinay Swami Singh,
the respond.
Gautam Raghunath,
No representation on the last occasion also. On the last occasion, on 15/7/2024, there was no representation on behalf of the petitioner. Counsel by the respondent was present. As the matter was directed to be listed for dismissal today. Here also, there is no representation on behalf of the petitioner. Hence, the petition is dismissed for non-prosecution.
till number 10. Murthy DL for petitioner. Vivekananda TP.
When 12/7/2024, the matter was called, there was no representation on behalf of the petitioner, and the matter is directed to be listed under the caption for dismissal. Today also, there is no representation. Accordingly, the petition is dismissed for non-prosecution. Yes,
Hearing on interlocutory applications, till number 11. S.V. Prakash for petitioner.
I am for petition. But IA 1 of 2024, bringing the loss of deceased petitioner for applicants. The petitioner died on 10/10/2023.
Who are the alerts now?
Legal estimate.
Which one? How many are the respondents? Who died?
Pardon,
How many are the respondents?
petitioner is sole.
Petitioner.
Yes, ma'am. There are four legal S.
Respondents, first respondent is served. Second, the notice,
Second respondent unserved.
the notice to
Not
the second
claimed.
respondent has not claimed. Hence, the notice to the respondent number 2 is held sufficient. Then where is IA number 1?
IA number 1 is 4.
IA number 1 is 5 to bring the alerts of the petitioner. It is stated that the petitioner died on 10/10/2023 and is survived by 5 and 3 sons. 3 sons. Accordingly, IA number, so IA number 1 is allowed, 1 of 24 is allowed. And the laws are permitted to be brought on record. And the petitioner shall file shall carry out the necessary corrections. Post this matter for hearing on 6th of August. Yes,
Number 12, parted matters, B and Shankara Gowda for petitioner. Murulian.
Petitioner.
then counsel for the petitioner submits that he needs to get instructions.
Interim order will be extended.
In the earlier matter, interim order earlier granted is extended till the next date of hearing.
Much.
Yes. Were you part of the execution proceedings?
I was not a party, but I got myself,
That's what is the order now.
yes, order 21.
Was
to
that
90.
question?
All that was
Was
done.
that question? And once
Was-
your
that is-
application was
It
dismissed,
is questioned in RA. Now
what
it
has
is,
happened to that?
it is pending. And original decree is also challenged, that RA is also pending.
So now, in that scenario, what is this order? Please come to the order again.
Yes. All that the court has said is that there are already, we have participated, we have suffered certain orders. And therefore, under circumstances, this application has to be allowed because the fifth respondent got the rights under a decree. This is all the case. I just take my lord's attention to the order.
You are the plaintiff in the suit. You are
No.
the plaintiff in the suit.
No,
Suit
in
is
the
for,
present, in the present suit, I am the plaintiff,
suit is for
partition.
parties.
And the relationship between the parties as such is not in dispute. The plaintiffs 1 and 2 and the defendants
The
1,
defendant number 5 is a subsequent purchaser
They are
from one of
purchaser.
your,
yes. I first take my lord's attention to the application that is filed by the fifth respondent.
so as of now, there is any stay or anything of the said in RA?
No, if there were to be, perhaps execution could not have been proceeded with.
But then in that case, what remains to be now is that this particular property, as far as that particular property is concerned, the proceedings as far as they stand now are in favor of the defendant.
Yes, it is.
And you have no order, so then this application has to be allowed. I mean, your petition has to be dismissed.
Has to be allowed, is my case.
Yes, please submit.
Because the two appeals are pending, they have not reached the finality.
Hmm.
Irrespective of the fact whether there is a stay order or not, that's a different issue. But fact remains, the orders are under challenge before the appellate court. And regular appeal is pending before the competent,
Hmm.
is my respectful submission.
Let's
Because
read, let's
sometimes
read the reasoning.
Many times a stay may be granted, may not be granted, it is all there, discretion of the court. But does not mean the rights are taken away of the parties. Now, presuming for the sake of argument, my lord, that I succeed in the suit for partition, what should happen? With respect to this,
So we'll just read from para 9 and then you can submit.
yes, there are 9, my lord,
Hmm.
yes. The learned counsel for the defendant number 5 vehemently argued that and submitted that the present suit filed by the plaintiffs for partition and separate possession is not maintainable against the defendant number 5. He further submits that the suit item number 1 is the subject matter of OS 40/2007 and EP execution petition number 92 of 2011. These matters are decided by the court on merits. The very plaintiffs are filed the miscellaneous petition against the judgment and decree passed by the trial court in OS number 40 of 2007. The same is dismissed by the court. Later on, the plaintiffs appeared in EP execution petition 92 of 2011 and filed the application in the Audit 21 Rule 9700 so and so. The same is registered by this defendant. Later on, the court has dismissed IA number 7 and 8 filed by the plaintiffs. Thereby, the plaintiffs are not having any right over the item number 1 of the suit real property. Therefore, the pleading stated in para 4 of the plaint and the name of the defendant number 5 in the cause title struck off in the interest of justice and equity. He has also relied upon the documents annexed with IA 4. Though these are the certified copies of the order passed by the first additional senior civil judge in EP 92 of 2011. The learned counsel for the plaintiffs vehemently argued and submitted that IA filed by the defendant is unknown to law. The materials placed by the defendant number 5 are not sufficient to struck off the pleadings and name of the defendant in the cause title. Moreover, it is a suit for partition and separate possession. The plaintiffs are able to prove the suitable properties are the joint family property, then they are entitled the partition. Otherwise, they are out of court. The reasons mentioned by the defendant number 5 are not sustainable under law. He has also relied upon the decision reported in civil appeal number so and so SC. Another case reported in K. Saraswati alias Kalpana versus so and so. Then High Court of Madras so and so. He has also relied upon another decision reported in Karnataka High Court in fact Advertising Private Limited, etc. I have gone through the contents of IA number 3 and objection statement. It is the case of defendant number 5. The pleadings at paragraph 4 of the plaint may be struck off. These facts are already decided by the court in OS number 40/2007, miscellaneous petition 4 of 2019, EP number 92/2011. On this point, I would like to go through the documents relied by the defendant number 5. These are the certified copies of EP 92 of 2011, objection statement by the plaintiffs, orders on IA number 7 and 8. These materials, documents discloses, the very plaintiffs are restricted the claim of the defendant number 5 in respect of item number 1 of this.
No, in respect of this particular suit schedule property, no, you have filed a regular appeal.
Yes.
Regular appeal. No, if that RA is decided, the rights would be decided in that petition with respect to the same property. So why it should again be a part of this suit?
Part of the present suit.
Oh.
My lord, where I am not a party there.
But you have filed a regular appeal because that order.
Regular appeal is filed not,
Against it's,
not by me, by the plaintiffs in that suit.
no. In that, when in the execution proceedings, when you got
Petition.
impleaded yourself and there was an order against you, you filed a first appeal against that,
Yes.
regular appeal. Now, in the regular appeal, like a suit, that particular item of the property will be decided by the court. So why should again it be decided in the very same issue that is already pending consideration before an appellate court? The court had rightly passed this order.
Issue there is arising out of the execution proceedings,
And about,
not suit.
no.
But
An
deemed,
execution
it could be
proceedings.
deemed a decree under order 21 rule 97. That is there.
Yes.
I'm not saying for a moment
Yes.
that it is not.
Yes.
But there, it is a limited question
No, whether it also refers to.
because all these pleadings will not be there.
No, but whether it is your property or not is the first question. According to the defendant, who is a defendant in this suit, he says that he has purchased the property and whatsoever grounds he has taken, and other defendants are parties to that suit. You are not a party to the suit. Then thereafter, you have impleaded yourself in the execution proceedings and an order is passed against you. You filed a regular suit. So in respect of that suit schedule property, all the parties are there in a way. You are there, the defendants are there, everybody is there in that suit. So it can be adjudicated. Let the court do that. Please come.
No.
Hmm.
Let me say, my submission to my lord is, I have not given. The agitation in a execution petition is altogether different. Agitating in a duly constituted suit for partition is a different. Suffices to state that I am not a party to the decree that is passed in favor of the defendant number 5 with respect to one property. I am not saying for him.
What
It
was
is-
that suit filed by the defendant?
For specific performance.
Hmm.
According to the respondent number 5, the 1 and 4 defendants
Executed a agreement of sale.
in his favor.
Hmm.
And that was not contested, of course, irrespective of it. Decree is a decree, consented or otherwise. So that decree is challenged by the plaintiffs themselves in that suit, and
Yes.
that RA is pending.
Hmm.
So
And in the meantime, they have filed the execution.
Yes, decree is not finalized because a subject matter of appeal, regular appeal is a continuation of the original suit, unlike second appeal.
On what basis your execution petition is, your petition is dismissed by the court?
I was not a party to it, therefore I cannot
Hmm.
agitate over the matter because it was a matter between the
Agreement holder and
purchaser and the vendors.
Hmm.
So now vendors have also filed an appeal against that decree granting specific performance to the respondent number 5. Pending disposal of that, he filed the execution because in the appellate court, there was no stay of the decree. So in the execution petition, the present plaintiffs who are not parties to the decree, they are not parties to the agreement to sell, all that is there. And therefore, they filed this suit. They could have filed this suit much earlier, I may say with great respect, instead of going to the execution case, this case, that case. No, after realizing that their rights have to be crystallized only in a suit for partition, not otherwise in an execution case and the like, they have filed this suit. And purchaser is a necessary party because without him, I cannot take a decree with respect to the property which is sold by my co-partner, in the sense my relatives, brothers or sisters, whoever it is. Under those circumstances, a regular suit is filed. And when the suit is filed, certain issues are also framed by the court. Kindly see the issues, which I invited my lord's attention to the other day.
Page number.
My lord finds on page 53, annexure F.
Yes.
Whether the plaintiffs prove that the suit shall properties are the ancestral joint family property of plaintiffs and defendants 1 to 4.
So I'm not able to find that. 50?
53.
Uh-huh.
53, annexure F.
Yes.
Whether the plaintiffs prove that the suit shall properties are the ancestral and joint family properties of plaintiffs and defendants 1 to 4. Not just the defendant is only a purchaser. Who is
Whether the
contesting?
judgment is binding on them is also an issue. Whether the judgment in OS number 40 of 2007 is binding on them is also an issue. Issue number 2.
Issue number 2 is plaintiff prove the judgment and decree passed by the OS number 40 of 2007 is not binding on them. Obviously not, because I'm not a party to that. Then whether the defend number 5, this issue is against 5. Defend number 5 prove that the court fee paid by the plaintiffs is not proper and correct. That is not
Yes,
important
please
one.
come.
The next one, whether defendant 5 prove.
Yes, yes, as the agreed with the orders passed in I number 3 in OS number 156 of 2017 dated 12/9/2018, the plaintiff is before this court. The plaintiff herein has filed a suit for partition and separate portion of the suit scheduled properties and to allot the share. The defendants 1 to 4 are the members of the joint family, and 5 is the purchaser of which property? Suit
Item
schedule
number 1.
is the purchaser of item number 1 of the suit scheduled property. Who the defendants 1 to 4 has executed an agreement of sale in favor of the in favor of the D5. Now the present application, that is I number 3, is filed by the defendant.
Right.
Filed by, no, this is by the defendant.
Defend number 5.
Defendant number 5 under Order 6, Rule 16 of CPC to struck off para 4 of the plaint item and also his name in the cost title of the plaint. It is his case that he had filed voice number 40 of 2007. No, just now you have drawn the attention of the court to the object, the issues. Where are they? Issues, page number 53.
53.
53. I had filed OS number 40 of 2007 against defendants number 1 to 4 in the present suit for specific performance of the contract. The suit was contested and the same to and the said suit came to be decreed. Thereafter, the defendant had filed EP number 92 of 2011. In that, the plaintiff in this suit has filed miscellaneous number 4 of 2012 to set aside the judgment and decree passed by the court in voice number 40 of 2007. The remaining defendants have not contested the matter. The miscellaneous petition filed by the plaintiff was dismissed on 4/2/2017 as he was not a party to the agreement.
I'm not a party.
That was the ground on which your petition was dismissed.
That is the ground.
Have you filed it?
I think it is
Oh.
not there.
That he was not a party to that. The defendants 1 to 4 have filed an RA against the said order. And also the plaintiff had also filed an RA against the same. And the same is pending consultation before the court. The court had framed the following issues at page number 53, extract all the issues. And next page, additional issue. Next page, 53 and 54. At that point of time, after that, this application came to be filed. Court had considered the fact that the plaintiff and the defendants have filed an RA that is pending. And the pleadings.
Here, my lord, I may permit it. Appeal is filed by the plaintiffs in that suit against the decree itself.
That and
As far as I am concerned,
you are
I
against that you're in execution.
21 rule 97.
Yes, that I have
Yeah.
recorded. Two different appeals against that. the court has come to the conclusion that in the suit already as far as the item 1 of the scheduled property is concerned, is already there is a finding. Again, it is not necessary to give any finding on the same subject matter on the item 1 of the property. Therefore, the court is satisfied with the reasons assigned by the defendant number 5. And defendant number 5 had made out a sufficient ground to strike off the plaint para number 4 and name of defendant number 5 in the cause title of the plaint. Hence, allowed the application. Agreed thereby, the plaintiff is before this court. Learned counsel appearing for the plaintiff submits that he had filed a suit for partition wherein certain properties are shown as a joint family properties. The defendant number 1 to 4, who are members of the joint family, without having no independent right to the property, had entered into an agreement of sale with the defendant number 5. As such, the plaintiff has already pleaded defendant number 5. He submits that the defendants conveniently had not contested the suit, and when he has filed, when the EP proceedings are filed, when he got himself impleaded, the court had dismissed it only on the sole ground that he is not a party to the specific performance suit, and the same cannot be questioned. Agreed thereby, he has filed a first appeal. He has filed a RA, and the defendants also filed an RA against the judgment and decree in a suit for specific performance. When counsel submits that in a suit for partition, the court has to decide whether the property is a joint family property. If it is a joint family property, what are the shares of the respective parties? And in that regard, already issues are framed. And at this point of time, deleting the item 1 of the scheduled property and also the defendant from the array of the respondents from the defendants, and also para 4, the striking of the pleading is not legal, and the court below failed to appreciate the contentions raised on behalf of the plaintiff. Next para. On 2/7/2024, when the matter came up, there is no representation on behalf of the respondents. On 12/7/2024 also, on the last occasion also, he has not come. On 12/7/2024 also, there was no representation. When the court was proceeding with the matter, then the learned counsel for the petitioner had sought for time for getting instructions. Hence, this matter is listed today. Today also, there is no representation on behalf of the respondents. Hence, and as this is a writ petition of 2018, this court is inclined to proceed with the matter on the merits of it. Next part. Having heard the learned counsel for the petitioner, there is entire material on record. The plaintiff had filed a suit for partition. In that, the defendants are 1 to 5. 1 to 4 are the family members. 5 is an agreement. 5 had purchased the property basing on 5 is an agreement holder in respect of items 1 to 4. In respect of suit item 1 of the suit scheduled property, whereby the defendants 1 and 4 have executed an agreement of sale in favor of D5. According to the plaintiff, they have no manner of right and title to execute a sale deed. Execute an agreement, have no manner of right and title to enter into an agreement. Whether the property is a joint family property, whether the defendants have a right to execute an agreement of sale in favor of the defendant. All these issues will be decided by the court. The plaintiff number 1, plaintiff before this court, had impleaded himself in the execution proceedings. And in the execution proceedings, the court had not given a court had dismissed the same only on the ground that he is not a party to the specific performance suit. In fact, in the suit, the issues are framed on the judgment and decree in the specific performance suit, whether the same is binding on the plaintiff or not, whether the suit schedule properties or the ancestral and joint family properties of the plaintiff and the defendant number 1 to 4. Whether the defendant proves that the suit is barred by principles of constructive res judicata. When all these issues are framed and the appeal that is filed by the plaintiff, all these issues cannot be decided. The court below ought not to have allowed the application filed by the defendant number 5. In the considered opinion of this court, the order that is passed by the court is contrary to law. Accordingly, I number 3, order passed by the court below in accordingly the following one, the order dated so-and-so, passed by so-and-so in I number 3, in voice number so-and-so is set aside. Which year is the suit?
17.
2017.
7. Right.
Accordingly, writ petition is allowed.
Right.
Yes, next.
Preliminary hearing B group, cell number 13. Siddharth Suman for petitioner, Rajgopal Naidu for the respondent.
Respondents, my lord.
Yes.
I represent the respondents, my lord. The respondent,
Petitioner is here.
yes, my lord.
Yes. Where is the impugned order?
My lord, I am the defendant. The plaintiff has filed 3 applications before the trial court. One is under section 151 to recall the order. In the recall the order of closure of his evidence, my lord. However, that we have to presume nothing is being mentioned in the application, which is the order that he is going to recall.
No.
My lord.
Suit is, when is the suit?
Suit is of the year 2013.
2013. Suit
13.
is for?
The suit is for a agreement to enter into another agreement. My lord, the case is that I am a developer. In a pre-launch.
Let us see the prayer or the relief that is sought in the suit. Where is the plaint?
For specific performance, my lord.
My lord, the typed copy.
Hmm.
Page number 50, my lord.
50.
I have also produced the certified copy. Typed copy is at page 50.
So, pass a judgment decree and define a specific performance of the contract, directing them to execute the proper stated in favor of the plaintiffs. Grant an order of permanent injunction. Yes.
There
The
was
suit
no agreement. In the pre-launch sessions, he came, he expressed his desire to purchase certain flat in certain area. At that point of time, there is no land, no approval, no construction. It is only that we said that we are going to do this. Whoever is willing, they can come and pay 5 lakhs rupees, book the flat. That is at that point of time he came. Then he want to execute that sort of agreement. However, I am not on that because now I am.
No, we are not on that point.
Please, madam.
When was evidence of the plaintiff is closed?
My lord, the
29/11/2016, my lord. 29/11/2016.
Tell me, your voice is not clear.
I have produced the order sheet. Order sheet is also with the file. It is on 29/6, my lord.
Your voice is not clear to the court, sir.
my lord, the land council has produced the order sheet last time. As could be seen from that 29/11/2016.
Open the door, please.
Yes.
Yes. Which page number?
My lord, it shows page 12, my lord, but there is no continuation. 29/11/16.
Page number 21, my lord. There is petition.
The order sheet last time produced, my lord.
It is on 29/11.
Orders on IA number 4 to 6, sir.
That is next date, my lord. Previous to that, on 29/11/2016, at the top of it, it is evidence of the PW1.
Then it comes that evidence of the PW1 closed and evidence of the DW1. That is on 29/11/16.
29/11/2016.
16, my lord.
Evidence is closed.
Evidence is closed, my lord.
Hmm.
After closure of the evidence, the defendant has not chosen to enter the witness box. He felt that the evidence of the plaintiff is sufficient to defend his case. He has not entered the witness box. Then he filed 3 applications to recall his evidence.
When
And-
is that filed?
My lord, those applications, we have annexed and these are all at page number 3 applications. One application, page 64. Another application 72,
1 minute, 64.
69, one first application under 151.
1 minute. That is filed on 30, recall application is filed on 33, 2017.
Please, my lord.
Then,
The other application also same day. Application
the other applications.
place 72 under 60, order 16, rule 1,
No, this IA for recall is IA number,
4, my lord.
next IA number 5.
Page 72, my lord.
Reopen
Under
the-
order 18, rule 17.
Hmm.
To permit him to examine their witnesses. Plaintiff want to examine the defendant's witnesses, my lord. The defendant never entered the witness box and order 18, rule 17, my lord is well aware that it can be invoked only where there is a person entered the witness box. Such person can be recalled for the satisfaction of the court to
Now, what is the next application?
Uh,
No,
that
item
is
number
at
5
page
is-
75, my lord.
Uh,
Page 75,
Hmm.
order 16, rule 1, giving the list of witnesses.
Rule 1.
Order 16, rule 1, my lord.
Let's come to the order impugned.
Place 75, my lord. My lord may kindly see, both the witnesses are Vaishnavi Infrastructure Private Limited. They are my employees. He want to examine, for that purpose, he filed application to recall the evidence and also to invoke order 18, rule 17, to put them into witness box. And these persons, we have filed the objections, we have contended, we have not entered the witness box. These persons, when they have not entered the witness box, order 18, rule 17 does not apply. That application shall fall. I have the judgment, I will place before my
Now,
judge.
let's go to the order impugned.
Please, my lord. And order 16, rule 1, it has to be filed, the witnesses shall be filed within 15 days. There is no margin, there is no liberty. Within 15 days, they have to file. This is more than about 2 years. So that application also has to file. And my lord, order 151, it is not a substantive provision, my lord. My lord is well aware. And it is only to undo a mistake or to do a correct thing. That's all, my lord. It can't be invoked where there is a specific provision.
So first we will look at the order, then we look at the provision.
Please, my lord. My lord, the order is at 24. The reasoning comes, my lord.
21, page number 21.
Are the reasons. The reason portion comes at 28, my lord. The court notices inordinate delay, however, ignores and then grant the relief.
Yes,
My lord, may I refer to order 16 rule 1, my lord.
CPC. CPC.
In rule 11, sir.
Please, madam, order 16 rule 1.
Order.
Order 16 rule 1, my lord. Summoning and attending witnesses.
Order 16. Rule 1. One minute. Yes,
My lord, it's only 3 lines, may I read, my lord?
yes.
On or before such date as the court may appoint, and not later than 15 days after the date on which the issues are settled, the party shall present to the court a list of witnesses whom they propose to call either to give evidence or to produce documents.
Yes.
My lord. And coming to order 18 rule 17, my lord. My lord, with regard to the order 16 rule 1, the learned judge notices there is inordinate delay. He won't give reasons.
Order
He
18.
Order 16 rule 1.
In
the
order
art-
18, rule 17.
Rule 17, my lord.
Yes.
My lord, may I submit, my lord. Order 16 rule 1, the land judge after noticing without any justification, without any reason, ignores and then passes an order. My lord, order 18 rule 17, here also, my lord, there is only one sentence. The court may at any stage of suit recall any witness who has been examined. My lord has dealt with the situation presiding in Telangana High Court. My lord, I have the judgment. Who has been examined and may subject to such land, so on and so on. So in both these applications, there is more than 15 days delay. Application has to pay, and I have never entered the witness box. I am the defendant witness, so that application also has to fail because he cannot fail an application to recall a person who has never entered the witness box.
Yes.
And with regard to the section 151, my lord, it's my lord discretion. It is not substantive provision, and only to undo a wrong, the courts by exercise the discretion and pass order. When there are specific provisions, invoking 151 does not arise. My lord, there are 3 judgments, my lord.
Yes.
My lord, first judgment I would like to refer to Tatipalli Vamsi Mohan versus Gilla Swarajyam. Honorable High Court of Telangana. My lord, here in page number 6, my lord was pleased to hold that page 6, my lord.
Yes.
The Land Council for the respondent relying upon the judgment of Andhra Pradesh High Court in Rayapani Umadevi versus Bhimineni Vamsi Kiran
Yes.
submits that the powers to recall any witness under order 18 rule 17 can be exercised by the court either on its host motion or an application filed by the parties to the suit. But such power is to be invoked not to fill the lacunas in the evidence of the witness which has already been AR 1964, AP 198 recorded, but to clear the ambiguity that may have arisen during the course of the examination, if the evidence of the or re-examination of a witness has to be bearing on the witness ultimate decision of the suit, it always within the discretion of the Honorable Court to permit the recall such witnesses for re-examination with permission to the court. He has also relied upon the Honorable Supreme Court in Vadiraju Nagappa. I have given the second judgment, Madam. Vadiraju Nagappa Varnekar versus Sharad Chand Pravakar, reported in 2009 4SCC 410, which has been dealt with by the Honorable High Court of Karnataka in Raibaneni case. For the same proposition, he has been relied on another judgment of the Honorable Supreme Court, that same repetition, my lord. And my lord's view at paragraph 7, admittedly, the cross-examination was completed and present application is filed to recall plaintiff's witness for further examination. The reason is stated that PWA 124 have taken contradictory statement in 161 CRPC statement, and further they want to put some question. As observed by the Honorable Apex Court, the application for recalling the witness for further examination, just like that, cannot be ordered, and particularly if the same is filed covering up the lacunas, the said application has not been allowed. In the same case, the application was filed by the defendant to cover up the lacunas in the cross-examination done by them. Hence, as suit is of the year 2018, the suit below has rightly disputed the application, and this court finds no illegality under the order in revision. Accordingly, civil revision petition is dismissed.
So in this case, how this order 18 rule 17 will come into play? There is
They
question-
filed, madam. They have filed order 18 rule 17 to recall the witness. Our case is that order 18 rule 17 only person.
Those witnesses were never examined to again to recall the same
Please, madam,
witness.
have the other judgment also, madam,
Mm. Yes.
on the same point.
Mm.
My lord, 2009 4SCC 410, Vadiraju, which was been referred by my lord in the previous
Looking
judgment.
at this Meera Muralidhar Bajaj.
Second one, my lord, and that is our high court. That also I can refer, my lord.
Yes.
That is the third judgment. Which one can I take, my lord? The Supreme Court, 2009 4SCC, and our High Court, Honorable Justice Krishna Kumar judgment is that Meera Muralidhar's case. In Meera Muralidhar case, paragraph 4 and 6 are relevant, my lord. May I read the relevant portion, my lord? Yes, please.
Then what is this AR 2001 Karnataka?
My lord, this is the judgment referred to in Honorable Justice Krishna Kumar's case, MC Ananda. Paragraph 8 and 9 are relevant, my lord.
Para 8?
Para 8, para 9, my lord.
You have already cited those witnesses as your witnesses?
No, my lord. My lord, this Vadiraju case, my lord, para 25 and 28.
Para,
25 and 28, my lord.
order 18, rule 17.
Please, my lord.
Yes, then the Veluswamy,
That is
Also
with regard to
order
the
date
section
17.
151. 151.
There are 16 of the judgment, my lord. Veluswamy's case, there are 16 of the judgment.
yes,
Yes,
what do
ma'am.
you say?
Milada, my humble request is that Milada, the defendants, the plaintiffs were away from the country, they were employed, and they did not get the details of these witnesses. I have produced 22 documents before the trial court to establish the case of the plaintiffs. They have produced. So the plaintiffs were away. Later they came and gave an evidence, but the defendants did not give any details of their employees who have booked the flats from the plaintiffs. Later, my lord, after coming to Bangalore in 2017, these applications have been filed. Because, my lord, the defendants did not led any evidence. I have lost the opportunity of cross-examining and elucidating about the contract between the parties. It is a suit for specific performance. They have received my money, and so far they have not cancelled even my the booking order, in spite of filing the suit. Lord,
Yes.
there are several issues to be finalized by the trial court. So there is a lapse on my part, no doubt, my lord, but it does not mean that that should be end the opportunity, my lord. One more opportunity should be given. It is the first application I have filed. What I have done is, my lord, that I wanted to examine the defendants, employees, because they are negotiated with me and on behalf of the defendants. They have sent mails, confirming mails, and they have received payment. They have confirmed, and several 22 mails I have produced before the trial court to establish this case. Because I have lost the opportunity of even cross-examining defendant witness to elucidate my case. In a suit for a specific performance, the opportunity should be given to the parties now.
Yes, Lord.
And I
Yes,
rely upon the very strong judgment, my lord, held by the Supreme Court, the latest judgment, that is the latest judgment, as far as my knowledge is concerned, my lord. And Article 16 Rule 1 does not say that it is only the plaintiff witnesses, even there, the plaintiff has the right to call upon the defendant to tender evidence on behalf of the plaintiff. And
Yes.
these circumstances, my lord, my applications have been rightly allowed by the trial court,
yes,
To be given an opportunity, I should be
The
given
matter
an
reserved, sir. Matter
Yes.
is reserved.
opportunity.
Cell number 14, K.M. Somsekhar for petitioner, V. Latif. K.M. Somsekhar, 14. V. Latif.
You have filed the affidavit in the last.
We have filed the affidavit, Your Lordship.
what is the affidavit?
Your Lordship, previously the petition was dismissed for non-prosecution. For the reason that one Somsekhar, who was previously our colleague, he left our office. That has been recorded. To produce additional documents, we had filed an affidavit, Your Lordship.
Where is the affidavit? Affidavit dated?
28/6/2024.
Affidavit date. Affidavit date. Not memo.
24/6/2017, Your Lordship.
26.
24/6/2017. A memo is dated 28/6/2024. Along with that, we attached the affidavit, which is dated, affidavit placed before the trial court, and that is dated 24/6/2017.
The last date Lordship has directed to produce that affidavit.
No, along with document, it is on 37/24. 37 now.
ತಪ್ಪಾಗಿಲ್ಲ.
Yes, ma'am. Yeah, take from.
It's there.
Seal on date is the date on date is the series.
No, this is an affidavit filed by the party before the court,
Yes, Your Lordship.
dated 24/6/2017.
24/2017, yes.
So before we go to that, now please tell the court, what is this, what is the IA impugned?
Your Lordship, we had filed an application to produce lease agreement, which is an unregistered and unstamped
No, what is the suit for?
suit for
Specific performance.
specific performance, Your Lordship.
Performance, you're the
Yes.
plaintiff or the defendant?
I'm the plaintiff, Your Lordships.
What is the IA that is filed?
IA is with respect to a document, that is the lease agreement.
Let us see that IA, because.
IA also not.
No, IA has been filed, but orders has been passed on admission of document, Your Lordship.
IA is not there and record ಇಲ್ಲ.
The relevant page is at 336. At the time of producing the documents, an order was passed with respect to admission of the document. And we have challenged that order.
Then why were you submitting something like dismiss for default and all?
No, previously, on the last occasion, I was not there. My apologies, I should have been informed. But previously, this writ petition was dismissed for non-prosecution.
That was
It's
restored.
restored.
It is
That is
restored, yes,
restored.
Your Lordship.
So that is not now an issue.
Yes, that is not. for
Now
consideration.
we are on the impugned order.
Yes, Your Lordship.
Yes. Impugned order is on admissibility of the lease deed.
Yes, yes, Your Lordship. One of the grounds, one of the reasons stated while dismissing admission of the document is that the learned judge invoked provisions of Karnataka Land Reforms Act, Your Lordship. It has no bearing on this property at all. They go on to examine tenancy and the lease under a transfer of property are not one and the same. And besides, this document has been produced for collateral purpose, to show that I'm in possession of the land. We are not claiming any right through the lease agreement. No right has
What
been,
is the specific performance you're seeking?
Your Lordship, defendant number 1, he executed an agreement in our favor.
That is the one.
Yes, Your Lordship.
Hmm.
And we are in possession of the land, even
No, basing on that, you
Yes.
filed a suit for specific
big
performance.
performance, yes.
So by virtue of this document, there was an agreement, and by virtue of that, you have been in possession of the property.
No, not by virtue of the agreement, sale agreement. By virtue of the lease agreement, I've been in
Lease
possession.
agreement, that's what I'm saying, lease agreement.
Yes, Your Lordship.
And that is the document which you're relying on.
Yes, Your Lordship.
Hmm.
I was put in possession by virtue of the lease agreement and not the sale agreement. Even before sale agreement could be executed, I was already in possession of the land.
So according to you, that is a secondary purpose.
Yes, Your
It was
Lordship.
argued by you in the last occasion. Yes.
It is for secondary purpose, for collateral purpose.
So
That's why-
it need not be those, so that a document is admissible in evidence.
Yes, Your Lordship.
Yes. What do you say?
Lord,
the dispute is with regard to the documents, because first of all, it is unregistered. Secondly, it is not stamped. It is merely a paper. And nothing, there is an indication in the the impugned order that it was not at all registered or unstamped. You want to consider it as secondary evidence that document is not valid as per law.
The
And
lease is for how many years?
10 years. And which is contrary to the pleadings of their own agreement, sale agreement, in which there is an awareness that the possession of that property is still with the vendor.
No,
And
no, in the
Sale
in the
agreement.
agreement of sale,
the possession was exclusively with the
vendor.
vendor.
No, they rely on this lease deed to say that they are in possession of the
They are
property.
in possession. That is a disputed document.
Deed is for 10 years.
10 years. And as per the Land Reforms Act, it is impermissible to execute those kind of agreements. As for the 10 years, there is a bar under the law. And since it is a void document, it cannot be marked. That is our objection.
Please come. The present writ petition is filed, agreed with the order dated 7/8/2017. The senior civil judge, wherein an order is passed on the admissibility of the lease deed. By order impugned, the court had dismissed the application of the plaintiff to mark the lease agreement dated 3/11/2005 in our evidence. The suit is filed. The petitioner before this court is a plaintiff in the suit. He had filed a suit for seeking specific performance of an agreement of sale dated
1/1/2009.
hmm,
1/1/2009.
1/1/2009. Now, it is the case of the plaintiff that a lease agreement was executed by the defendant. Where is the lease agreement?
Not produced.
Without producing any documents, how can you file the writ petition?
As per their pleadings, it was on 3/11/2005,
3/11/2005,
prior to the sale agreement.
that is, which is prior to the sale agreement. And by virtue of the lease agreement, the plaintiff is put in possession of the property for a period of 10 years. To prove that he is in possession of the property, the plaintiff wanted to mark the said lease deed, which was objected by the defendants that as it is a insufficiently stamped, unregistered document, as such the same cannot be marked in evidence. The court will, huh? Page number? Take that. The court below, by order impugned, had rejected the said plea of the plaintiff, wherein the court had observed by virtue of the document, 0.60 acres of land situated in survey number 98/V2, situated at Category Village, was leased out to the plaintiff for a period of 10 years, commencing from 3/11/2005 to 2/11/2015. And the lease agreement is fixed as 50,000 as per the lease agreement, the sum of rupees 50,000 per annum has to be paid as lease amount. The property is a agricultural land. The court has observed that section 5 of the Karnataka Land Reforms Act prohibits the lease of agricultural land. As per section 5 of the Karnataka Land Reforms Act, after the date of the amended act, no tenancy shall be created as continued in respect of any land, nor shall any land be leased for any period whatsoever. The act came into force on 2/10/1965. And after 2/10/1965, no tenancy shall be created or continued in respect of agricultural land. The court has also observed that the defendant is not a soldier or seaman, so section 2A of the act is not applicable. And the document itself is in a void ab initio, so it cannot be marked in the evidence for any purpose, and accordingly reject the same. The learned counsel appearing for the plaintiff submits that this document they are relying on for the purpose that they are in possession of the property. It is for the collateral purpose. As such, though it is a unregistered document, still the court ought to have considered this, or could have taken the same for the said purpose. It is submitted that the court went wrong in considering the provisions of the Karnataka Land Reforms Act, which do not apply to this case, and particularly when they wanted to mark the said document as secondary evidence. And as such, the petition has to be allowed, and consequently, the application needs to be allowed. Learned counsel appearing for the petitioner, defendant submits that the plaintiff is coming up before the court with inconsistent stance. As per the agreement of sale, which was entered much after the lease deed, shows that the possession is with the vendor, and basing on the lease deed, now he tries to submit before the court that he is in possession of the property. He submits that even without going into looking at the Land Reforms Act, a lease deed which is unstamped, unregistered, cannot be admitted in evidence, even for the even as a secondary evidence also. As such, the court below had rightly dismissed the petition. Next part, having heard the counsels on either side, there is the material on record. The present suit is filed seeking specific performance of an agreement of sale. Now, by virtue of this, in this IA, the plaintiff wants to mark a lease deed which was executed by the defendant, which was executed by the parties for a lease for a period of 10 years. Now, any document that has to be when the lease itself is up for about 10 years, it is a compulsory registrable document. Now, coming to the aspect of the possession, when the main suit itself is filed for an agreement on for a specific performance, when they are relying on an agreement of sale, and in the document, when the possession is stated to be with the vendor himself, now by inconsistency, the plaintiff cannot take that apart, as this is a insufficiently stamped document. It cannot be looked into for any other purpose, and accordingly, suit petition is dismissed. This next.
Cell number 15. Cell number 15. Dr. Reddy for petitioner.
At the request of learned counsel for the petitioner, this matter is adjourned on 14/6/2024 and 4/7/2024. Today, there is no representation on behalf of the petitioner. Pose this matter for dismissal on Monday, on the top of the list.
Cell number 16. M. Mohan Kumar.
Yes. This court, by order dated 21/9/2023, has disposed of the MFA and directed the trial court to dispose of the MVC within a period of 5 months from the date of receipt of the copy of the order. Now, a letter is addressed by the learned judge seeking extension of time that he had taken charge on 28/5/2024. And the impleading applications has been allowed. And the respondent number 3 was impleaded on 29/5/2024. And the respondent 3 insurance company is requesting time as the records are pertaining to 2009 as are sought for 3 weeks' time to 3 weeks' time, 3 months' time to dispose of the case accordingly. As sought, the time is extended by another 3 months. Yes. Yes.
Cell number 17. Other secretary for petitioner.
And exit page number 83. What is this? 89.
ಗಂಡ ಸಾಲವಾಗಿದೆ. She is no more.
No, I will not do that. Wife and son filed this petition.
When is it dated? 26/2/2016, 22/12/2015.
This is the order.
Whereby the marriage is dissolved and permanent antimony of 10 lakhs is directed to be agreed.
And the memo filed for. But this is the order for. My submission is on the face of it. There was no local order on that day. And this matter was not referred to local order at all. That you will not to find page number 89. Only by judicial conciliator. No local order was constituted. And thereafter, this he filed, this petitioner filed application.
We will call for the records. We will know what it is. Where is that? No, if it is certified copies, we'll look into it. Why should we call for? No. You are saying that no such, there was no sitting on that day.
No local.
That's what.
That is found from the order itself. 89, page 89. Advocate conciliator, no signature. 22/12. And before that, you have to kindly see, I produced the typed copy. Typed copy, you are not
kindly follow that, page 92. Kindly follow the art sheet. 17, page 93, my lord. Connection here, thank you for immediate reference. 93, page number 93. Was at the stage of evidence, 17/12/2015. Document kindly follow. 17/12/2015, the date of hearing. Was cop of PW1, evidence was recorded and it was a cop of PW1. Both parties present, both counsels present. Counsel for respondent files, there are copy of order MC number 230/2030. That the divorce petition and petition. The order was. Both counsels to say on the said order, call on 1/1/2006. This is the order on 17/12/2006. Abruptly on 22, no, there is no request, there is no application. Abruptly on 22/12/2015, the matter is placed for local. There was no local constitution, that's my second. And thereafter, the petitioner filed application before the trial court.
Where is that?
That your lordship finds. Inaction. Page number 107.
107.
7. Page number 109 may kindly be there. Fine. 16/8/2016. Order. I filed this petitioner filed application saying to recall the order passed on 22/12/2016. On the ground that he was not well, he was not appraised of the compromise, and parliamentary the husband persuaded the wife petitioner for filing compromise petition. That was my the application filed by the wife. And during the pendency, my lord, the husband died. And
So the court has dismissed on the ground that you can't question it before the court. Yes.
Now I am telling both here. Now, the only question for your lordship consideration is whether the Legal Services Authority Act, that your lordship filed. Section 19(5) and 22 aspects. One is against the MC petition. By the time this memo was filed, against MC petition, there was the wife filed MLA before this on the court, and there was an interim order of state land. And the matter was pending. Now the matter is now decided in favor of the wife. Though the husband died, because with regard to the status of the wife, whether the divorce order, divorce judgment passed by the trial court is accepted proper or not, that was the question. And in a compromise, before this criminal dispute, what is not to be compromised is the matter pending before this on. That was the memo.
When was an order passed in MFA?
Before this conference, whenever the MFA is passed, or is passed.
What is assailed before the court in MFA?
The divorce judgment was assessed by the wife against the husband. And husband died during the pregnancy of this child. And then the respondents came up as legal aids. This is that judgment is not before, not in this file, therefore I am seeking leave of the. There are other proceedings also.
We'll just ask him once again and last. We'll just ask him once. Yes, what is this? When is the judgment and decree? What is this appeal and what is that legal services authorities say?
Judgment and decree, in MC case was made in the year 2015. And she had filed an MFA.
That came to be allowed.
MFA came to be allowed last year.
No, no.
Not then when the joint memo was filed. MFA was pending when the joint memo was filed.
No,
She
no.
had undertaken in the joint memo to withdraw the MFA what she had filed, selling the decree of divorce.
Oh, he's making serious allegations like Lok Adalat was not conducted.
It's false, my lord. It's quite patent.
And
from
that
the order
too,
sheet
just like
itself.
that, when the matter is pending before the court, one can go to the Lok Adalat without even any reference from the court.
It's a matrimonial issue before all the courts that were pending. Before this.
The court will
honorable
refer it, and I'm just asking about the procedure.
Yes.
The court will refer it to the Lok Adalat, or they themselves will go before the Lok Adalat.
If the parties can have.
Even when the
taken
matter is pending.
initiative to refer
No,
it to
no,
Lok Adalat.
the parties can ask the court. But then the court should pass some order saying that the matter is referred to the Lok Adalat, so and so. Something should be said there should be an order by the court. No, the matter is pending, matter is posted for cross-examination or whatever it is, then suddenly you find this Lok Adalat award. Where from it has come?
My lord, if the matter is pending, my lord, that's enough for initiating the process or facilitating for settlement between the parties.
No, that's what is
At
what.
any stage of the case.
No.
So these
It
aspects
can,
will not.
no, it can be. But now, for example, now this writ petition is pending before this court. And I posted it for something. Now both of you will go without any order from the court to the mediation. And the mediation, it will be settled and the court will pass an order. Is it so? Or the matter is pending before the court, when both of you want, the court will refer it to the mediation.
My lord,
Or any legal services authority or.
when the Lok Adalat is being held, the parties can approach the Lok Adalat and seek for reference of their case to be decided there, as the parties have already come to some settlement terms. When that is so, the Lok Adalat will call for the file and it will take up the case and record the joint memo.
No, why the
and
signature
accept-
of the other person is not found there? Conciliator, the legal conciliator, his signature is not found in that.
Well, not merely because the advocate conciliator is absent, my lord, the Lok Adalat will not be cancelled. Because the judicial conciliator will proceed to put a quietus to the litigation when the parties have arrived at a joint settlement.
No,
Some
but it is a
terms-
formality that, when there are two members are there, a judicial and an advocate, both of them should at least sign it. Without, how can it be? No, in the light of what he is submitting, we'll call for a report in this.
Yes.
The present writ petition is filed, agreed by the order passed by the court below, where the court had refused to entertain the application of the petitioner to set aside an award passed by the Lok Adalat. It is a case that an award was passed on 22/12/2005, dissolving the marriage and directing and also that the husband has to pay 10 lakhs to the wife. It is a case of the wife that when where is that page number? You are referring to the docket, that order sheet. That the matter came up on
22/12/2015.
on 17/12/2015, where the court, the audit sheet reveals that the parties are present, both counsels present. Counsel is counsel for respondent files a Xerox copy of order MC number 230 of 2013. Both counsels to say on the said order call on 1/1/2016. Thereafter, this court finds that before Lok Adalat held on 22/12/2015, wherein as per the joint memo filed, a permanent alimony of rupees 10 lakhs was granted. As per the same, the award was as per the award. That then a permanent alimony was granted. Then counsel submits that when the matter came up on 17/12/2015, there was no order directing the party that on the request of the parties or the court for going for any Lok Adalat mediation or the settlement. According to the learned counsel, no such Lok Adalat was held on 22/12/2015, and the order is not signed by the advocate conciliator. It is only signed by the judicial conciliator. Yes, now by all these allegations, he is attributing fraud to the fraud being played.
These two contentions, what he is telling, my lord, these are improved one. In the application, your lordships will not find any of these aspects. She admits that a Lok Adalat was there. She admits that her counsel had called her to sign the joint memo. She admits that she has signed.
Where is that? Where is that?
In the application, my lord.
Let's
It's
see.
in the language of Kannada, my lord. 96, my lord.
Is it so?
Even in the evidence, what she leads before the trial court.
You will find out. It's a factual aspect. What is that? And so and so. The registrar judicial is directed to call for the records pertaining to the Lok Adalat as well as the proceedings before the court pertaining to the above referred dates and the case. Pose this matter on 29th. By the time the record shall be placed before the court. Yes.
Then number 18.
My lord, serial number 18, I appear for the petitioner, my lord. My lord, we have given it for signatures, my lord. The IEA came up on 12/7/2024, my lord. The petitioner was traveling to Delhi, my lord. For that reason, my lord, we couldn't obtain his signatures. My lord, request for 10 days time, my lord.
Oh, it can't be 10 days. It's a
My lord.
2017 matter. It is 2017 matter. Why should we wait?
My lords,
Already enough time is given to you.
My lords, what had happened was, my lords, on the last occasion, I had pointed out to my lords with respect to the order to permitting us to serve a copy of the entire writ petition to the trial court advocate,
No, that
my
has
lord.
not happened.
After,
That has not happened. Now we are in 2017. Court cannot grant you
Please.
10 days time. At best, it
My
would
lord.
come up on, it would come up on 24th. Pose this matter on 24th. By the time the application for substituted service is not filed, the writ petition shall stand dismissed without further reference to the court. Yes.
Please, please, my lords. Deeply obliged.
19.
I appear for the petitioner, my lord.
Yes.
I am for the petitioner.
Yes.
But the dependents writ petition, plaintiff filed the suit.
Yes.
This dependents writ petition, plaintiff filed the suit for declaration and permanent injunction. But after completion, there is a dispute regarding the boundaries of the scheduled property and as well as the dependents' properties. After completion of the evidence, the defendant filed the application under Order 26, Rule 9. to appoint the commissioner. The application is at page
Please
20.
come to that order.
Order it at annexure A. Relevant portion is page 15, madam.
Yes.
I have perused the application IA 15 and objections, plain governments and documents. The
Suit is
relief,
of which year?
so suit is in the year, madam,
2001.
2001.
2001. IA is
2001.
filed when?
IA
IA is filed in 8/12/2016.
No, after completion of the evidence, because before completion of the evidence, I could not file the application because in view of the judgment of this honorable court in ILR 2007 Karnataka page 3029, only the application for appointment of commissioner is to be filed after the evidence. After the evidence, when the matter was listed for final arguments, I have filed this application for appointment of commissioner. That application was rejected on the ground that it is filed belatedly at the time of arguments. That is why this application rejected. The matter is already heard at length, already PW 1 to 4 and exhibits P1 to 17 on the side of plaintiff. Evidence is placed, and also that the defendant side is also examined and got marked exhibit D1 to D8. When the case is posted for arguments, this application is filed. No reasons are forthcoming and IA is rejected.
Please read the para number at page number 15.
Page number 15 only I am reading. I have perused the application, IA number 15 and objections, plain governments and documents. The relief claimed in IA number 15 is for appointment of Taluk surveyor to demarcate the schedule mentioned in the property in IA number 14. The defendant has not sought the demarcation of the suit property. Instead of that, the defendant sought for other than this suit property. It is pertinent to note that the defendant has not claimed any counterclaim in respect of the suit schedule property. Under such circumstances, the relief sought by the defendant is not tenable. The matter is already heard in length, already PW1 to 4 and exhibit P1 to P17 on the side of plaintiff. Evidence is placed, and also that the defendant side
Where is the IA application for this?
yes, madam, that is important. That is page 24, madam.
Please read it.
We made appoint the Taluk surveyor Pandupur Taluk through the Tahsildar Pandupur to demarcate the schedule below mentioned property by the commissioner as a subject matter of the suit comes within the boundaries given below, and to meet the NG, just subject to suit schedule properties comes within its properties. That is why the bifurcation of the document property of the plaintiff and defendant, the appointment of commissioner is necessary. I have clearly stated in page 25, para 3rd may kindly read under these circumstances. Page 25 in my affidavit. I swear on oath that the defendants have taken the defense that there is no existence of the suit schedule land as mentioned in the plaint, and further the defendant pleaded that the application schedule mentioned landed property purchased from his previous owner, one Puttaswamaya, and his children for valuable consideration, and the plaintiff had to knock off the land as given the wrong boundaries as filed the suit. Further, defendant has pleaded that the plaint scheduled land comes within the boundaries mentioned in the sale deed and rectification of deed of the defendant. Hence, to demarcate the same, this application is filed to appoint Taluk surveyor as a court commissioner for the better appreciation of the evidence led by the plaintiffs and his witnesses, myself and my witnesses, and though the sketch produced by me along with the written statement as such denies the averments alleged by me in my written statement in the interest of justice. This is the application I have filed.
But for adjudication of the correct position, the appointment of commissioner is necessary. As held by this honorable court in ILR 2007, Karnataka, page 3029.
When is evidence completed?
Now, immediately after completion of evidence, I have filed
We
this
should know
application.
what is the date. When is the evidence completed?
My lord, exactly, my lord.
When was the evidence completed? When was the evidence completed? Evidence.
My lord,
You're forgetting.
immediately after the completion of the evidence, I have filed this application, but actually, when exactly the date is not available in the present. The record is necessary to know when exactly So the court says immediately after completion, when the matter is listed for final arguments, this application is made. Only this honorable court has said only after the evidence, only the appointment of commissioner is to be made. Application is to be filed as required. And in another judgment, in AR 2016, Orissa, page 24, it is very clear. Thus, the dispute cannot be finally resolved without conducting the measurement of the co-suit, plot, and adjoining plots of survey knowing persons. It was observed that whether two plots are adjacent or not can be ascertained from the report of the commissioner. The AR 2016, Orissa, page 24. My colleague is there, he is furnishing the two judgments.
Yes.
Page para 7 of the judgment, ILR 2007, Karnataka, page 3029. But para 7, it is settled position of law that the court commissioner cannot be appointed to collect the evidence in support of a claim. After completion of the evidence on both sides, if it is found that there is any ambiguity in the evidence adduced by the parties, then the court may appoint commissioner for the purpose of clarification of such an ambiguity. In the instant case, the evidence is not yet commenced, and therefore the question of ambiguity in the evidence will not arise at this stage. The trial court, without considering the settled position of law, committed an error in passing the impugned order and appointing the court commissioner. On this ground, the impugned order is liable to be quashed. Here is the case. The appointment of commissioner is made before evidence, before the evidence. Here is the case. In my case, in the present case on hand, the application is filed after completion of the evidence. There is an ambiguity in the evidence to find out the suit schedule properties, whether comes within the schedule of the defendants or not. For that purpose, it is necessary to appoint the commissioner. Even the Orissa High Court AR 2016, Orissa, page 24, para 10 is very clear. The instant case may be examined on the annual of the decision cited supra. The plaintiff claims to be the owner of the land appertaining to plot number 706 under Kata number 276 of Mauj Mohan, out of which defendant number 1 is said to have encroached upon a portion of measuring 15 by 15 cubits. In the written statement, defendant number 1 denied have encroached upon any portion of the land out of plot number 706. His land is that he is the owner of land bearing plot number 707, over which he has constructed a residential house without encroaching upon the land of the plaintiff. The suit was dismissed by the learned trial court, mainly on the ground that the plaintiff failed to establish any encroachment in the suit land. The learned lower appellate court is right in coming to the conclusion that there appears to be boundary dispute between the two parties. Thus, the dispute cannot be finally resolved without conducting the measurement of the suit plot and adjoining plots by a survey knowing persons. It was observed that whether two plots are adjacent or not can be ascertained from the report of the commissioner.
Yes.
So the appellate court has undoubtedly the power of appointment of survey knowing commissioner when the controversy is in identification of location of measurement
Yes.
of the land premises or objects given to quite issueless. For the formal effective adjudication of dispute, it is necessary to appoint the survey knowing commissioner for demarcation of the land.
Yes, please.
So
go.
for the demarcation of the plaintiff and defendant's property, it is necessary to appoint the commission.
I number, the present petition is filed agreed with the order passed in I number 15 and order 26 rule 9 that with 151 CPC, whereby the court had dismissed an application filed by the defendant to appoint an advocate commissioner. The petitioner before this court as a defendant in the suit. The respondent herein has filed a suit for declaration and injunction.
Permanent declaration and permanent.
Declaration and for permanent injunction. The dispute is, according to the plaintiff, he had purchased the property, the plaintiff's father. No, the deceased plaintiff has purchased the property by way of a sale deed dated 9/8/1971. It is a case of the defendant that he has purchased the property.
Purchase previous owner, one Puttaswamaya. One Puttaswamaya.
It is the
Not
case of the plaintiff that the defendant is claiming the land by including the plaintiff's property by giving wrong boundaries with an intention to knock off the plaintiff's scheduled property. When they find an application before the court to appoint a surveyor as a court commissioner for the better appreciation of the evidence, the same was objected by the defendant. The court, the trial court, considering the respective objections of the parties, had dismissed the application, observing that the defendant had not claimed any counterclaim in respect to the suit scheduled property. Under such circumstances, the relief sought by the defendant is not tenable. The matter is already heard in length, already PW 1 to 4 and exhibit P1 to P17 on the side of the plaintiff evidence is placed, and also the defendant's side DW 1 to 5 are examined and got marked exhibit D1 to D8. When the case is posted for argument, the present application is filed. No reasons are forthcoming why the application is not filed at the earlier stage. As such, the reasons stated are not tenable and accordingly dismiss the petition. Aggrieved thereby, the petitioner defendant is before this court. Learned counsel appearing for the petitioner defendant submits that the whole dispute between the parties is that according to the plaintiff, he has purchased, the deceased plaintiff had purchased the property way back in the year 1971, and the defendant had purchased the property in the year 2001. According to the plaintiff, the defendant has shown the wrong boundaries and included the plaintiff's property also. He submits that if a court commissioner is appointed, the surveyor is appointed as a court commissioner, all these things will come to light. He had relied on a judgment of this court in Renuka versus Sri Tamanna and others, reported in ILR 2007 Karnataka 3029, wherein the court had held that even before the evidence is complete, unless and until there is any ambiguity, the question of appointing an advocate commissioner would not arise. And he submits that in the light of the said order passed by the High Court, even before the evidence is completed, he cannot file such an application. He submits that now, if this application is allowed, both the two facts will be placed on record. And that appears to be the whole dispute. The court would be able to dispose of the matter in an effective manner. Next, the next one. On 18/6/2024, when this matter came up, there was no representation on behalf of the respondent. Today also, there is no representation on behalf of the respondent, as the writ petition of the year 2017 listed in the caption final hearing. This court is not inclined to adjourn the matter. Hence, the court is proposing to pass an order on the merits of it. The suit is for declaration and injunction, and there is no dispute about the fact that both the plaintiff and the defendants have purchased the property, their properties. One is in 1971, that is the plaintiff, and the defendant in the year 2001. Now, the whole dispute of the plaintiff is that the defendant had shown the wrong boundaries and also included the property that is belonging to the plaintiff. Both the parties have adduced their evidence, and after once the evidence is completed, the present application came to be filed. Then counsel had relied on the judgment of this court in refer supra, and considering the same, the application would be filed when there is an ambiguity in the evidence, and it is required to be that there would be a requirement for appointment of an advocate commissioner. Considering the dispute between the parties and it only revolves around about the boundaries, and if the surveyor is appointed, in fact, it would be even in the interest of the plaintiff also. And the court below, without considering all these facts, had dismissed the petition. Hence, the order under revision is set. Hence, the court is passing the following order. One, the order dated so-and-so in IA number so-and-so, in MC number, in OS number so-and-so is set aside. Consequently, IA number 15 is allowed, and accordingly, the petition is allowed.
Cell number 20, preliminary hearing, cell number 20.
Yes.
Kiran Michael.
No representation for dismissal on Monday. Yes.
Cell number 21.
Yes. How much is granted? No, what is it meant by saying that not allowed?
Statement of assets and liabilities have not been filed.
Why it is not being filed? Let us see from the order what is observed by the court.
When the petitioner, that is right, also not produced the bank statement, page 54. Page 54. 8 lines from bottom.
Page 52.
Page 54. Impute order. Then they say the petitioner has also not produced the bank account statement from the last 3 years.
And even respondent, there is husband, petitioner had also not filed a statement of objection.
Why he has not filed is the question.
The discharge order was placed and the order was recorded. And I filed the petitioner husband, the respondent, filed objections to memo. Memo filed treating it as an objection to IA. The very next day on the spot, without giving opportunity to parties to argue the matter.
How much is your income?
Income is around 10,400 rupees per day you will get by painting.
Child is also there. Any children out of the wedlock?
Two major children are there, they are working.
They are staying with whom?
It report says that
Anyhow, pay 5,000 bills. How much is, when is the petition filed? Date.
Presume that he is getting 1 lakh as per this statement made by the respondent. And she had, prior to filing the petition, she had allowed with the driver. Along with gold articles and cash kept in the house. That was the consideration.
So you said what is the date of petition? 18/3?
The date of filing application for maintenance is 29/3/2023.
2023, 24, 25, no, 16 months. 16 months. Please come. Then counsel for the petitioner submits that the petitioner is a painter and his monthly income would be, his daily income is 400 per day. He could not even file his statement of assets and liabilities, and the court had granted maintenance of an amount of rupees 10,000. It would be very difficult for the petitioner to pay the said amount. Considering the submission of the then counsel, they shall be stay of all further proceeding portion to so and so, on the condition that the petitioner shall continue to pay 5,000 by 5th of every succeeding month, and arrears for 16 months at 84,000 shall be paid within 4 weeks from the date of receipt of the copy of the order. Either the 5,000 or this amount is not paid, the stay granted by this court stands vacated without further stand vacated automatically. Next, the petitioner shall take out notice on the counsel appearing before the court below and file my memo to that effect by 29th of July. Post this matter on 18th of, not 18, on 21st of August. Yes, next.
Till number 22.
Huh? 5,000.
10,000 they get stay.
That's what I said. You will be paying 5,000 in this, on that condition. Yes.
Till number
My-
22.
My lord, I am preparing for petitioner. My lord, the petitioner is the respondent before the trial court. Respondent number 1 is the wife and respondent number 2 is the son of petitioner. The respondents have filed a petition under section 125 CRPC seeking for grant of maintenance of rupees 45,000. They have also filed an IA, that is IA number 2, seeking for grant of interim maintenance of 45,000. My lord, the trial court has awarded maintenance of 20,000 to the respondent number 1 by virtue of its order dated 17/10/2023 at Annex D. So far respondent number 2 is concerned, it has awarded rupees 20,000, my lord. So, it has not awarded any maintenance amount to respondent number 1 because there is an evidence to show that she is an employee and she is income tax payee. My lord, now it has come in the implemented order itself that I have to pay, I have been paying EMI of rupees 65,000 per month towards the loan, which has been
When is the date of order? Date of order.
Date of order is 17/10/2023, my lord.
Date of that petition for maintenance.
Petition was filed, petition has been filed on, in the month of February 2019.
2019.
2019. February 2019, order has been passed on 17/10/2003. And my lord, at present, I go on paying the maintenance of 20,000 to the respondent number 2. I have been paying. I undertake to pay. I go on paying. But my at this stage, I restrict my relief with respect to the stay of arrears, my lord, because the order has been passed from the date of the petition, my lord, and I am having
You
parents.
have to pay something towards arrears.
My lord, I fairly submit 25% of that amount, maybe in respect of 75%.
What is the 25% of that amount?
50, my lord.
What is the 25% of that amount from for the arrears?
It comes to 11,20,000 towards 56 months. 11,20,000. It comes nearly 25%. It comes nearly.
Then pay 4 lakhs. Pay 4 lakhs first.
3 lakhs. And that may be, but there may be an order to deposit in the name of respondent to, my lord, not in the name of respondent 1, because respondent 2 is my son.
Counsel for the petitioner submits that the court has granted a maintenance of an amount of ₹20,000 and he has been continuously paying. As far as the arrears are concerned, as it runs into crores or lakhs of rupees, it would be difficult for the petitioner to pay. Hence, they shall be stay of all further proceedings on the condition that he shall continue to pay 20,000 per month as directed by the court, and he shall deposit an amount of ₹4 lakhs towards arrears within 4 weeks from today. Same, if that or this is not complied, and he shall take out notice on the counsel appearing before the court below and shall file a memo to that effect by 29, and same, it should come up on 18th.
In the name of respondent 2, my lord. I may be.
It shall be deposited in the name of respondent number 2.
Great.
Like earlier matter. Demands. They have given a memo. 2:15, get it. At 2:30, list it at 2:30.
Milords, serial number 18, Milords, interim order may kindly be extended, please, Milords.
Last occasion also you were not present.
Milords, I was present, Milord.
1 minute, 1 minute. But what to do? You should be present here, or at least your colleague should be there. Last occasion also the same thing has happened.
My apologies.
That order dismissed matter, item number so and so. Pass over. Let's see. Tell the other counsel.
Milord, serial number 18, Milords. It got over, Milords.
Oh, sorry, 1 minute, Mr. Counsel. 1 minute. Yes. Yes.
Serial number 18, Milords, interim order may please be extended.
That's already extended. You have informed the court that time also.
Please, Milords.
Section 18, interim order extended or not, just look at it. No, there are no mentions now. Which matter? When it is resolved, it means it's continuing. No mentions, please, because its matter is dismissed, I heard it, not all the matters.
One matter, notice has to be ordered. Yes, this matter was clubbed, 23, next matter.
23, next matter, my lord.
It has to be
My
clubbed, and today I am serving the copy of the
Serial number
petition.
34.
Date may kindly be fixed. Your lordship
What is happening is, it is becoming so embarrassing for the court to reject refuse any of your requests.
No,
And
even,
unfortunately, I cannot hear the matters every day, morning, afternoon, evening on a request. We'll call the matter. So what is to be done in this 23?
23, in writ petition number 17305, which is filed by the wife.
Yes.
Copy of the petition has to be given to the husband. Notice has to be ordered.
In other 2 matters, I appear, my lord. I have filed the other 2 matters.
So
Connected.
why can't you appear in this matter?
That's what, my lord. Now they are serving the copy. Now, first time.
No, issue would be the one and the same. You know, what is the impugned order would
No,
be
my
the
lord.
one
Now
and
they
the
are serving
same.
the copy now, my lord, because the first time they filed it very recently.
Mr. Muniswamy Gowda
Yes, ma'am.
is directed to take notice in WP number 17305/2024, post all these matters on Tuesday.
My lord, serial number 34.
And
Copy, sir.
copies also,
Sir.
sir.
My lord, serial number 34. Raise time, my lord.
You can pray the time when the matter reaches also. Yes.
court is dismissed, it's withdrawn in the morning.
What is, yes,
28.
28, land council submits that the senior is not feeling well. The poses matter on 25th.
ಸದಾನಂದ ಅವರೇ, ಇದೊಂದು 28 ಅಂತ ಕೊಡಿ. ಇದು ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 18 ಅಲ್ಲಿ previous date ಅಲ್ಲಿ ಆರ್ಡರ್
ಆಮೇಲೆ ಒಂದು ಮೇಘಂಗ್ ಒಂದು ಫೈಲ್ ಮೇಡಮ್ ಮೇಘಂಗ್ ಹೇಳ್ಬಿಡೋಣ ಮಂಡೆಗೆ ಹಾಕು ಅಂತ.
ನಾವೇನ್
ಮೇಡಮ್ ಮೇಘಂಗ್ ಡಿಸ್ಮಿಸ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮಂಡೆಗೆ ಹಾಕು ಅಂತ ಹೇಳ್ಬಿಡ್ಲಾ? DNP ಆಗಿರೋದ್ನ ಮಂಡೆಗೆ ಅಂದ್ರಲ್ಲ. ಆಗಿದೆ ಸರ್.
ಅವಳಿಗೆ ಹೇಳ್ಬಿಡಿ ಅದು. ನಾನು ಇಲ್ಲಿ ಬರ್ಕೊಂಡೆ 23 ನಲ್ಲಿ
ಮುನಿಸ್ವಾಮಿ ಗೌಡ
that first matter ಅಲ್ಲಿ Sri Muniswami Gowda SG is directed to take notice for respondent and list this in WP number 17,305 of 14/24 ಅಲ್ಲಿ 17,305 of 24 ಅಲ್ಲಿ Muniswami Gowda is directed to take notice for respondent. Copy served. Copy served. They have served the copy. ಆಗಿದೆ. So list this matter on 23/7 next week. ಯಾವ್ದು ಮೇಡಮ್? 28 at the request of learned counsel for the petitioner on 25/7. ಯಾವ್ದು ಮೇಡಮ್? 22 ನಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಸ್ಟೇ ಇದೆ. 21/8 ಅದೇ previous
ರೀಕಾಲ್ ಎಲ್ಲ ಮಾಡ್ಬೇಕು. DNP ಮಾಡಕ್ಕೆ ಬೇಕು.
ಅಪ್ಡೇಟ್ ಮಾಡ್ಬಿಡಿ, ಅದಕ್ಕೆ ಬರೋದು ಚಿಂತೆ ಇಲ್ಲ. serial number 20 ನಲ್ಲಿ no representation on behalf of petitioner. List this matter for dismissal on 22/7. 2:30 ಅಲ್ಲಿ 2 o'clock.
ಮೇಘಂಗ್ ಲೇಟ್ ಆಗಿದೆ ಮೇಡಮ್.
ಪಾಸ್ವರ್ಡ್ ಬಂದ್ಮೇಲೆ ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡ್ ಬಂದ್ಮೇಲೆ ಗೊತ್ತಿಲ್ಲ ಸರ್. ವಿ ಕಾಂಟ್ ಅದೆಲ್ಲ ನಾವ್ ಹೇಳಕ್ಕೆ ಆಗಲ್ಲ. ಅಲ್ಲಿ ಬೇಗ ಮುಗ್ದೋದ್ರೆ ಬೇಗ. ಸೊ 18 ಅಲ್ಲಿ ಏನ್ ಬೇಕು ಸರ್? ಏನ್ ಬೇಕು ಮೇಡಮ್? 24 ಒಂದ್ ನಿಮಿಷ.
Please come.
Pass over. Serial number 88. 13 BS partition.
Yes.
But briefing counsel is not available. They may part the briefing, part matter, we are, I will do it on, sorry. Tuesday are very convenient.
Pose this matter on Tuesday at the request of non-counsel for the petition. Yes.
Please.
Yes.
Serial number 25, 24. Revana Siddhappa.
Enhancement. Take out notice. Counsel is permitted to take out take notice on the counsel appearing before the court below and file a memo. Then counsel, the petition is permitted to take out notice on the counsel appearing to the respondent before the court below. And shall file a memo to that effect. Shall file a memo by Friday. If the memo is filed, post this matter on 29th. Friday 26th, post on 29th.
Serial number
Huh?
30th.
31st. Yes.
Serial number 25. GM Srinivas Reddy.
It's a wife's petition. Wife's petition or husband's petition? Children 1,000 and 2,000 rupees each, 1,000. Total 5,000. How can, then who will take care of them?
Then after filing of the petition, before started for the MC number, we give a 2,000. Then after come forward for the against your since 2013, we are unable to number. They are saying that he is a contractor from
No, how much you're going to pay now? Take notice, such a small amount. That's why take notice, we will see. Additions. How can an amount of 5, then who will take care of them? Who will accommodate them? Who will? They have to eat something and sustain. Site will not give them that. 5,000 is a very meager amount. Any plumber can pay it. Why he can't do? What is his age? What is his age? For that he is not able to work. Only simple, now issue is like this. If you are ready to pay the amount, will state, otherwise you have to take notice. Only 2 options you have. Arrears and also continue to pay some amount. What is that amount? You have to tell the court. Get instructions. Post this matter tomorrow. Otherwise it will not be stayed. Yes.
Serial number 26. Manjuna, here for petitioner.
Forty? That is restitution. Oh, what are your grounds? What are her grounds? You are on cruelty. She is on?
He had also alleged done the harassment and cruelty. I had also alleged done the harassment and cruelty. But that the family court heard that. But wrote the petition filed by the suspect. Dismiss my counterclaim only on the ground that there is no specific prayer in the counterclaim. So that may kindly come to the order of the.
Which order you're questioning now?
The judgment passed by the family court was challenged by the wife before the son of the court.
Yes.
Son of the court set aside the judgment passed by the family court, remanded the matter. And the family court in order to consider affect that. When IA training for consideration was not considered by the family court. But thereafter, after remanding the matter, the wife filed an application seeking amendment of the counterclaim, which I have used at page number 117.
Amendment was filed when?
It was filed after remanding the matter.
The counterclaim was filed when?
And 3/7/2016.
MFA was dismissed when?
The MFA was allowed on 3/2024.
When is this petition filed?
But the substitution was filed on 19/1/2024.
Let's see the order. Page number.
Page number 15. Page number 15. But after it, page number 25. Paragraph 12. Paragraph. As ending the above effort is as per Counsel to ask the 613 amendment and the board of only in force of conclusion that in spite of due diligence, the party is not arranged to matter before the commission. But now this application is filed not in the course of the whereby has already completed judgment that has already been filed.
Where is that page number? Page number you're reading it?
25.
Yes.
Party should not have raised the matter before commencement of the trial. But now, this application is not ready in the course of trial, whereby trial had already completed, had already been passed. Court had immediately observed with regard to the second hypothesis of the respondent. So now, immediately because matter is demanded for disposal based on IA number 10, the respondent had.
This is a prayer.
No, it was not a prayer.
No, this is what is amendment you want at page number 16. 16. That's what you're reading now. No, I'm looking at 16. Please take 16. This is a counterclaim you want. Then what did the court say?
The court said that since trial are already completed and judgment was already passed and he was required in the appeal that matter was demanded that. In that circumstance, court said that it can be considered. So that last year there will be judgment passed by the Supreme Court. The page number 105 we can do this.
Then counsel for the petitioner submits the court below without considering the grounds raised by the petitioner has dismissed IA number 2, filed under order 6 rule 17. read with section 151 CPC. He submits that even if the amendment is allowed, no prejudice would be caused to the respondent. Considering the same, there shall be stay of all further proceedings in MC number 1266 of 2016 for a period of till the next date of hearing. For this matter on August 5th, the petitioner shall take out notice on the counsel appearing before the court below for the respondent and shall file a memo by 29th. If the memo is not filed, the interim order granted by this court stands vacated automatically. If the trial is conducted, then why are you filing this application? No, if the trial has to go, then then where is the need of this?
I have even filed my amended code. Yes, the amended code, though I'm reading my further evidence. So I'm reading my further evidence. So it is posted on my cross-examination.
No notice, take out the notice to the respondent. Petition is permitted to take out notice on the counsel. It is more or less a formality that you are doing now. Yes.
Till number 27.
Yes. No interim order. Notice 29 on 5th. Yes.
Till number 27. Syed Akbar Pasha for petitioner.
Yes. Where is the wife staying? Then where she is staying, that it should be there only. Take out notice, will see. Petition is permitted to take out notice, same 29th. No. 5th August. 5th August. And you have to take notice and file a memo by 29th. Then only it will come on 5th. If the notice is served, then only list this matter on 5th. In both the matters. Yes.
Till number 28, adjourned 29. 29. Sanjay Bhai.
No representation. For dismissal on Tuesday.
My lord, serial number 29, I appear for the petitioner, my lord.
Yes.
My lords, the court has passed an order for appointing a court commissioner, my lords. I have produced the medical certificates of the petitioner stating that he is recovering from prostate cancer. And I've taken the same, and I filed an application for
Come to the
adjournment.
impugned order.
The
Page
impugned
number.
order is at page number 50, my lords.
Yes.
Page number 50, petitioner and counsel present, respondent absent. Advocate for respondent present and files adjournment application issued by Dr. Matangi of BGS Global Hospital. Peruse the records. Respondent is hereby directed to take steps for appointment of the court commissioner to record evidence of the respondent. My lords, I'm aggrieved by this order and the petitioner is still recovering, my lords. I've produced the doctor certificate also in that regard. However, the court has
What is the
sought
MC
for.
for?
My lords, the MC is filed by the respondent herein for seeking divorce, my lords.
So what is the difficulty if the court commissioner is
My
appointed?
lords, the health of the petitioner as of now is not conducive for conducting evidence by way of court commissioner, my lords. And there's a annexure F which I've produced, and there are certain documents which I need to produce before the court. And for cross-examination, it is better if it is done by a judicial officer than a court commissioner, my lords. That is my humble submission. Therefore, I had also sought for
But
my
that is
interim.
not, no, you tell the court how
My
it
lords,
is not.
My lords, the present petitioner is still recovering, my lords, and it currently is not in a position to come and depose before the court or for commissioner. He is still recovering. That medical records along with the
No, I'm not able to
documents.
understand what you are submitting.
Yes, ma'am. My
What is
lords,
that you
the
want?
petitioner.
First, you say that there shouldn't be a commissioner. Second, he will come and appear only before the court, but not.
Yes, my lords. But presently his health is not in a circumstance where he can appear before the court
Then
or
you should
appear
have told
before
the
a court
court.
commissioner. my lord.
You should have.
My lords, that I have produced before at page number 50, there's a specific document also which is recorded by the court, my lords. It's issued by the doctor herself.
What is the ailment
That
you are
he can,
saying?
my lords, he's suffering from prostate cancer. He's still recuperating from the same, my lords. Therefore, there's a, according to my instructions is that he'll require at least 2 to 3 months to recuperate from that.
The petitioner is suffering with cancer, and at this stage, he is not in a position to give evidence by commission. And considering the stand he has taken, the evidence could be taken before the court. Considering the health condition of the petitioner, there shall be stay of all for the proceedings in so and so so and so. Petition is permitted to take out notice, same 29th, 5th.
Right.
Yes, next.
Matter 230 matter.
Where are the counsels?
Kapil Dikshit, Saravana S.
My lord, for the petitioner.
Yes.
My lord, from 22nd to 27th, my lord, there's exams for the child. My lord.
From when to when?
22nd to Friday, 27th.
22nd to 26th. No.
22nd to 26th, Friday.
No,
my
it
lord.
should be from when?
My lord, the 29th, my lord, from the next Monday, my lord.
Yes.
They move the matter on the premise that there are exams.
From 22nd to 26th.
In the meanwhile, I sent an email to school, communicating the order path to the school. Court said we make necessary arrangements and school has said that we make necessary arrangements. And they permitted for the assessment by you. Time slips back to
My lord, it's they have permitted, my lord. It's just that the child is she can finish the exams and then get admitted. We're not.
I think like the mother should feel happy that something good is going to happen to the child. Why she unnecessarily
Sure,
wants all this?
Sure, my lord.
Then let it go on like this.
My lord,
As per
one
the earlier
submission.
arrangement.
My lord, one submission, my lord.
Yes.
My lord, one submission. The paternal grandmother is very old, so she needs assistance. So it's just that 6 weeks, all three of us, we are fine with it, my lord. We will let the father also stay from the beginning of the first week itself. All 6 weeks, the entire family getting evaluated, my lord.
That is not either of your, the court also can't direct. Whatever the doctors feel, they will do it. Will not tell. No, that's why I didn't say it should be mother, grandfather, everybody are at their this thing. Whatever they say, you have to do. Where is the memo that is moved before the court? And where is that? You have also filed that?
No, that's not filed. In fact, I was not informed about the filling of this memo. Only today I came to know that the matter is taken.
This court by order dated 10/7/2024 directed the What's that order? That's the latest one. Oh. Did you get the dates in the order?
That was indicated in the open court. Initially, 15th was sought to be set as the
So how
date.
come it is missing? I clearly stated the date, 6 weeks and all. You don't mention nowhere in the order. This court, by order dated 10/7/2024, has directed that as per the report of the enhanced, that the girl shall be admitted as inpatient for 6 weeks. Now, a memo is moved before this court stating that her exams are from 22nd to 26th. A memo is moved by the mother stating that her exams are from 22nd to 26th. As such, she will be admitted after Friday. The counsel for the father submits that the order of the court is communicated to the school authorities, and they have stated that they'll take care of they'll make arrangements at, what did they say?
May I read it, my lord,
Ah,
only a
please.
small. As requested by the High Court and for the benefit of Arohi, the school approves the request to have Arohi miss school for period of 6 weeks to attend the sessions at Nimhans. We sincerely hope this does not impact her academic progress.
They have
and she-
also permitted that she can be admitted considering the said submission, and also in the interest of the girl, it is necessary that she should be admitted. Hence, the girl shall admit in the hospital on 22nd. As already directed by this court, whoever has to be present as an attendant there with the girl shall be as per as felt necessary by the hospital authorities, and all the parties shall cooperate with the hospital authorities. Post this matter on 6/9/2024 under the caption part.
Great.
Much obliged.
Yes.
Partition matter, sale number 30. Sale number 30. I appeal for the petition, my lord. I have just received the NOC now from the other advocate. Kindly give me a day's time. I will take instructions from my client and
Monday will take.
please.
This matter, please your lordship,
Please,
you know,
my-
the child was to be produced before this court today, please your lordships. From today, for 15 days, the child had to be given to the custody of the respondent father. So this is a contempt which they have not brought the child before this court, please your
I have
lordship.
to take instructions and I have heard
Instructions you have to take.
from
You have
the-
to-
my
That is the
colleague.
instructions you have to take by this time. No,
No, I have
changing the
received only
counsel-
now, my lord. I have received only now. Kindly give
changing
me
the
1 day's
counsel-
time.
Please listen to the court.
Yes, my lord.
Changing the counsels is not what is the concern of the court.
Yes,
When
ma'am.
there is an order of the court, why is it not complied with?
My lord, she just availed job now and she is unable to take her leave. Kindly allow her to just.
I know this is what
continue.
has happened. That's how the
Yes, my
matter
lord,
is
you are
posted.
aware of it
But-
because it's a partnered
But she
matter.
will face the consequences. Post this matter on Monday.
Yes, my lord.
By the time the girl and the mother shall be present before the court.
But she's just availed job now. Kindly permit her to
Can't
work
help
there
it.
so that she also gets some.
Did she
training.
file an application before the court?
Yes, I will do it, my lord. That's why I sought permission
That-
today.
Give that.
Please, my lord.
No. We can't, you can't, at the request,
Her sister
taking
is
an,
also-
no, not necessary, her sister, her brother.
They have
we are
appeared
not
before
looking
this
at.
court and.
Now, when an
I'll take
order is, by
instructions.
the order of the court, you left the country.
Yes, my lord.
When there is an order that you should come, you
You
should
should
come.
be back. Yes, my lord. I
Yes.
understand. I
And so
agree.
no excuses, no
Yes.
nothing.
Yes, my
This
lord.
court by order dated 23/20/24.
My lord, I've been
by way of an
requesting that she's
elaborate
availed the
order.
job
No,
now
we
and she's.
will not expect
She will
anybody-
definitely come as per the court's
The
order.
process of
Kindly
the
permit
court.
her to.
No,
And I will take instructions and I.
no, not required. This court by an elaborate order dated 23/20/24 had permitted the mother to take the child to Dubai
My colleague is.
after
He
completing
wants
the
to file a
academic year in
modification
July.
of the. This, my lord.
The mother should get back the child to India. And further, once the child is brought back to India in the month of July, the father should be given the custody of the child for 15 days so that the father can spend time with her. And directed the matter to be posted on 18/7/2024 as part heard. Today, the council submits that she had filed the NOC and she would get instructions. This is not a case where instructions can be obtained. When there is a specific order from the court, when by the month of July, if she is not coming back to India, in spite of an order by the court, at least much before this, she should have filed an application before the court, stating that for various reasons, she is not in a position to comply with the order. But unfortunately, no such application is filed. Now the council submits that they will come up with such an application. No litigant can be permitted to abuse the process of the court and take advantage of an order and at the same time do not comply with the other part of the order. Pose this matter on Monday. On Monday, by the time, if either both the girl and the mother should be present before this court. If not, appropriate orders will be passed by the court.
Please, Your Lordship. Added to that, the father has also paid the school fees and the admission is.
But we will see later.
Please, please.
Let her come. Yes.
And hearing B group, serial number 31. Shankarappa S for petitioner, Fayaz of BG for respondent.
Respondent in this case, Lord.
Proper memo of retirement not filed by advocate for petitioner.
In this case on 6/3/2015, the marriage between this petitioner and respondent
No,
was taken.
before that, we have to just see what is this.
This writ petition has been filed against the interim order of maintenance caused by this family court, that is senior civil judge and JMFC Anekal. That order has been challenged before this court. That order was passed on 22/4/2019 annexure, page 25 law.
Let us see. I'm
Please,
looking at the memo of retirement first.
Sorry.
That has to be, unless and until that is, he is permitted to retire. And without hearing them, how can we pass an order? Where is that memo? This one paper. Post this matter for dismissal. Monday.
Yes.
Yes.
Serial number
No
32.
representation on behalf of the petitioner. Yes, 32.
32. Vijay Shetty.
Lots, I appear for the respondent number 7. Lots. I have filed my wakalat today. Lots. I pray for a week's time to file my statement of objections. Lots. There are some documents to be placed on record.
This matter on 23rd, 24th, at the request of learned counsel for the respondent, no further time would be granted. Yes, 33.
33.
Grateful.
For the respondent.
Appearing for the petitioner, my lords. Both sides are filed. Both parties are also present, my lords.
Take it. So you want to, with the, who filed voice number 2444?
The petitioner, my lords, who is the plaintiff before
Who is the petitioner?
the company IFB Agro Limited.
You want to withdraw the suit?
The writ petition, my lords.
Give the file. The present writ petition is filed, questioning an order passed in I number 2 in OS COM.OS 24444 of 2018, dated, what is the date of order?
Yes, my lords. The order is dated 23/10/2020.
23/10/2020.
20.
2020. And a memo is a joint memo for withdrawal of this writ petition is filed, stating that pursuant to the order dated 27/9/2022, passed by this court, the interim order passed by this court, the parties have negotiated and discussed the matter in length and have reached a commercial understanding, and that settlement involves supply of materials by the petitioner to the respondent. In the light of the same, the petitioner seeks leave of the court to withdraw the petition filed before this court, and the respondent has no objection to such withdrawal. Thereafter, the petitioner undertakes to withdraw the suit before the commercial court, and which is signed by both the petitioner and the respondent and the counsel for the respective parties. When this matter has come up on the other day, this court has insisted for the appearance of both the parties. Now before this court, both the petitioner as well as the respondent are before the court. Under an inquiry by the court, it is stated that the petitioner wants to withdraw the OS number in the light of the agreement entered between the parties. Taking this joint memo withdrawal on record, the petition is dismissed as withdrawn, and in the light of the memo dated so and so. Yes.
My lords, one request, if this order may be uploaded online, because there is a stay in my suit by this or in this writ petition, they have traveled from Calcutta. We'll take measures to advance the suit before the trial court. So if only this order could be uploaded.
Could be.
Oblige, my lord, oblige.
Yes, great.
Cell number 34 disposed, 35. Cell number 35.
Yes.
Okay.
For the respondent in this case, madam. Some settlement is going. Settlement is going on, my lord. A short.
Whenever the matter lists settlement talks.
No, my lord, serious settlement is going on. A short.
CPC of 2022, no urgency now. Post this matter on 13th of August. It is submitted that the settlement talks are going on between the parties. Yes.
Same, 36 also same.
36 also
35,
same.
36.
Same, 35 and 36.
Much obliged.
Yes.
But stay may be extended till next week.
Intermod earlier granted
Both
is
the
extended
cases.
till then. From Monday, only 2016, 17, 18, 19 will not have all these 2022 matters or CPC. FC all the matters.
My lord, serial number 32.
32. Where are you?
24/7.
24. It is already adjourned.
At the request of learned counsel for the respondent and
Yes.
24/7.
Or 4 base.
Yes.
Cell number 35, 36. Cell number 37.
37 appearing for petitioner, my lord. I seek for a short accommodation, my lord, in this case.
Post this matter on
Monday or Tuesday. Or
no, Monday, Tuesday. 22 matters will not take up on from Monday. Post on 13th of August. Yes.
Cell number 38, disposed, 39. Cell number 39.
The petitioner husband.
What is the matter about?
Husband has filed the petition, my lords. He has challenged the interim maintenance passed. Interim maintenance is about 50,000 what is passed. I am seeking modification of that order, my lords. The respondent is working and she is getting about 61,000 as her
Post
salary.
this matter on 25th. Yes.
My lords, can I request it on 26th, my lords?
26th. No, we'll have it on 29th.
Very well.
29.
Much obliged.
Yes.
Cell number 40. Rajendra.
I appear for petitioner in this. Steps has been taken, Lord.
Taken?
Yes, Lord.
Delete from the caption dismissal. Land counsel for the petitioner submits that the steps are being taken. Post after service of notice. Yes, 41.
Cell
Much
number
obliged.
41. BBM.
ಪೆಟಿಷನ್ ಕೇಸ್ ಇದರಲ್ಲಿ ಕನ್ವರ್ಷನ್ಗೆ ಅಂತ ಪಿಟಿಷನ್ ಮೆಮೋ ಫೈಲ್ ಮಾಡಿದ್ವಿ WP ಬರಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸೊ ಅದಕ್ಕೆ RPCಗೆ ಕನ್ವರ್ಷನ್ ಮೆಮೋ ಫೈಲ್ ಪೆಟಿಷನ್
What is the order that is questioned? You want to convert it?
Yeah.
Anyway, we can see it. The present petition is filed. Where is the order? Agreed by the order passed in criminal miscellaneous number 74 of 2021, dated 3rd July 2023, whereby the court had dismissed where the court had granted maintenance of an amount of rupees 7,500 per month to the petitioner from the date of petition till she remarries or until further orders. And also 5,000 rupees. Litigation expenses of 5,000 is granted. Agreed thereby, the present petition is filed. The office has taken an objection with regard to the maintainability of the appeal. The land counsel for the petitioner submits that they will convert this into a RPFC. Accordingly, the petition is permitted to withdraw this petition and liberty is granted to convert the same and for filing an appropriate petition. This conversion shall be done within a period of 15 days, or else that no further time shall thereafter they shall not be permitted to convert. Yes.
Hearing on interlocutory application 42. Party in person.
For respondent number 4 in this case.
Jyoti.
ನ್ಯಾಯದಲ್ಲಿ ಪ್ರಾರ್ಥನೆ.
Not the office of the writ petition has not been served.
Served on you. Serve him the copy. You have to serve the copy on the other side.
ನನಗೆ ಇದ್ದಿದ್ದೇವ್ರಿ ಇದಿರೋದು ಪಾರ್ಟಿನ್ ಪರ್ಸೆಂಟ್ ಕಮಿಟಿಗೆ ಅದು ಇದು ಕಳಿಸಿದ್ದೇವ್ರಿ ಅದನ್ನೇ ತಪ್ಪು ಇದ್ದಿದ್ದೇವ್ರು.
No, I'll pose this matter before other court. Tell him that. Because,
No. Copies
Tell
of
him
the writ
that.
petition and annexures.
ಮೊದಲೇ ಕೊಟ್ಟಿವರಲ್ಲಿ
ಬೇರೆ ಕೋರ್ಟ್ ಮುಂದೆ ಪೋಸ್ಟ್ ಆಗುತ್ತೆ.
Both the party in person speaking in Kannada, with which this court is not conversant with, post this matter before the other court after obtaining necessary orders from the Honorable Chief Justice. Yes.
Number 43.
I appear for the respondent.
Yes.
Kindly request to pass over.
But I'm filing my objections along with the documents.
What are your objections?
Lord, basically, we are stating, my lord, that the child is of, minor child is only 3-year-old, and that is in a transition period, my lord. Some of the photographs that are produced will show that is still on the diaper, is still on the diaper. When we send the child to him, it does not even change the diaper. One of the photographs, may kindly see, my lord, your lordship, may kindly see the photograph at page 24. I've given the document. Page 24.
The fact is that he is not used to, or I mean, he has not reared the child throughout because
We'll just, we'll start from the beginning. What is this email? Mail dated April 29.
Lord, request to kindly pass, our senior is on the way. Just 5-10 minutes.
Let her argue. In the meantime, let him come. Yes.
My lord, sir. Apologies, my lord. Senior is stuck in traffic. He'll require another 10 minutes to reach, my lord. Kindly pass
In the
over.
meantime, she'll argue. Yes. Yes. What is this at page now? First, I think there is no pagination to this. The first page, mail dated April 29, 2024.
he doesn't drop the child on the time. He's always late in dropping the child, my lord. I'm waiting outside. He doesn't come back at the time that he's picking up. He picks up on time, but doesn't drop the child. We are waiting. He doesn't come, bring the child on time. Which page is it? The next email, my lord, page number 4. Again, he doesn't drop the child on time. Page number 5, my lord, that the child is not taken care, not fed properly at the time when the child is there.
What for this photograph?
Well, these photographs are showing the, well, the child returns back, he's tired, fatigued, he eats, he sleeps. These are all psychosomatic.
I'm looking at.
Please, my lord, that is the timing, my lord, we have taken what time the photograph is taken. He's having dinner, as soon as he comes home, he has dinner and hits the bed. He's exhausted. I mean, there's all a factor of stress, the child not being away with the man.
What is his age?
3 years.
Then why
Yes,
is he,
3 months.
why bottle feeding for him?
When he's sleeping, he needs that milk. When he goes to sleep, it's not that bottle, that is where it's a transition stage, where still the breastfeeding was going on till some time, only later that it's been stopped. And then the timings, to note the timing, he goes to sleep, my lord, rather, as soon as he comes back on the weekend, he's stressed out going and being away from the mother. These are all psychosomatic issues that develop in this child at this age. Then, my lord, we have sent an email to him, my lord, that the on Inaction B at page 19, where we say what is the meal the child is to be eating and what time the child eats and sleeps. But he doesn't follow this. He was breastfeeding him until he was put into the play home along with the additional feeds that were there. So therefore, this need to have this, when he goes to sleep, the bottle melon. These are all showing that this child is stressed out and staying away for such long period, not getting proper rest at home, and that is manifestation of the stress the child is undergoing, my lord. At Annexure B, my lord, page 19. We have informed, your lordship is at page 19, my lord.
I am at Annexure B.
B, please, my lord. Sorry, my lord, the numbering is done at the bottom of the page, my lord.
No,
Here we
19,
tell.
page number 19.
Please, my lord. that when he's traveling in the car, he should be in the toddler's, that should be the seat the child should be. And then what time he has to have breakfast, what is his meal time, what is his sleeping time, nothing of this is followed. Food is ordered in Swiggy, junk food is being given to the child, where we have to see the child has to develop a healthy habit. The schools and the nurseries, they said do not send junk food. And now the child is fed only junk food and ice cream, and he has cold ice cream is given to the child. Cold soft drinks are given to the child. And sugar has not been inculcated to the child. And this, but going in the weekend, the child gets all this. Sugar is some food that everybody has to avoid, is what the doctors are saying. And that is an addiction, and that is leading to obesity. And children are now going, the health is going for a toss because of these reasons. And the next email, my lord, your lordship had given us permission that he should call when the child wants to speak to the mother. He doesn't give the call to the child, but tells the child your mother is busy. And the child comes and accuses, why you do not want to talk to me? At Annexure C at 17th April, that is what he says. Neil tells me time and again that when he wants to talk to me, you don't call me over the phone saying mommy is busy, or making some other excuse or the other. About the junk food also, my lord, we have raised it in Annexure C at paragraph 10. We have said how the child requires rest. He is not used to looking after the child. He is alone in Bangalore, my lord. He doesn't have a fully functional home in Bangalore. Page number 21 at the bottom, my lord, para 10. Feeding him junk food, letting him not sleep, take rest in the afternoon, he is exhausted. But despite bringing it to his notice, these changes are not made, my lord. Now the rearing habits of the child, this is where the discipline has to be inculcated in the child at this age. He wants to be a Santa Claus father, and he is doing what he wants to do. And in the Annexure D at March 30th, an email said, if not feeding him ice cream and cold drinks is not done. Don't do this. And often, my lord, after I started going to the play home, my lord, one or the other child has a cold, cough. So every other day, something or the other with the child. Now again, we continue to do it. That is not something, it should not be happening for the child. The child has to develop immunity. Diaper is not changed. Even when they were going for visiting rights, my lord, it was the mother who was to do the changing of the diaper. If the child has potty, it is the mother. The child is given to the mother to do the potty, because she is always there. The mother was there during this visitation rights until your lordships modified the order. Mother was present physically during the visitation rights. This is the first time since March your lordships has modified. The child is alone with the father, or the father is taking care of the child independently without mother being there.
With your lordship's kind permission, my lord, may I make one request?
Yes.
My lord, may I request a passover by 10 minutes, my lord? I'm sorry, I was stuck in traffic on the way. I beg your lordship's pardon. 15 minutes I'll be there, my lord. If the matter is just taken up in 15.
Yes. Why this application? Page number 30 you filed. Additional affidavit.
My lord, he goes to the school. Whenever he is in Bangalore, he goes and meets the child in the school. My lord, we have filed an application in the family court. Please refrain from going to the school. There are two reasons, my lord. One, the child is just by going to the school, and this discord should not be known. The child should not be queried and questioned as what happened, why your parents are not together. Whatever differences they have, it should be handled within themselves and within their homes. And they should go, whenever they're going, maybe a parent-teacher meeting or such meetings where parents are allowed to go. He will go, he'll stop there, coming back. When she's picking the child, there will be a scuffle, there will be an argument. This should be avoided, my lord. Therefore, we have filed this application. It is in the family court.
Couple between whom?
He'll go talk to the child. The child may not want to talk. Then everybody watches, my lord. In the school compound, outside the school compound, every parent comes to drop or pick the child. One parent will come. He will be waiting, and there will be a between the spouse, but in the mother and the father of the child, there will be an exchange of verbal exchange of the words. Now he has visitation rights. If he did not have visitation rights, going to a school premises would have been, is it necessary? I asked the question to myself. Now there is a visitation rights every weekend. He takes the child and he from morning 10 o'clock to 5 o'clock, he is there with the child. Then why go near the school? That is all harassment to both of them, mother and child. Why should the friends of the school or the teachers in the school should know what is the differences that are there? They can remain cordial as a parent in the school. Differences outside the school in the courtroom. The battle should be in the courtroom or whatever it is. So far as the visitation rights are, my lord, less battles are better, my lord. Now, why should we give room for that is a question I asked to myself. Then this application is pending there because we did make a mention that some of the applications are pending, but therefore we filed this, my lord.
And what is at page 38?
30, my lord?
38.
One more. He is called on what days when the child is with him, how many times he is called us. Though there is a permission to call, some anxiety of the child, one call or two calls that yes, she is not going in the way and saying, okay, come back. Now, when the child says, I want to talk, your lordship has directed him that he should be permitted and he does not do that. And when she calls, he does not even take the call. Just to check on, my lord, once a child is stabilized, then it would be a different matter. Now, the first thing that what we have to see, my lord, the welfare of the child. Here is the father who is exercising his claim as a right of a father. As soon as he comes home, he misses his normal food, not because there's no cooking done in his house. It's like a guest house. He comes on the weekend on a Saturday and Sunday. To say that he has a home is really not a functional home. And then dust is there, not cleaned, food is not available. And he is the only one who is there. There are no maids or no one to assist him. When he is otherwise busy, the child is with the phone. The child is watching and playing games on the phone. Lord, at this age, exposing the child to the screen time, electromagnetic waves, what is the impact on that? For his brain is not yet mature at all. I can't say even enough. It's still growing. What would be the impact of that? Every other studies have shown that the children should have no screen time. And let him fully be developed. And it should be minimized as much as possible, my lord. They're always playing on the games when he is otherwise busy. That's what the child has been doing. And now he is exhausted. And also what happens to his vision, my lord? Is still all his nervous systems are not completely grown. He's just a small 3-year-old child. Now to treat the 3-year-old child like a 10 or 12-year-old child is not, cannot happen, my lord. And he has to be treated in his age how it has to be done. So he has to avoid the complete screen with the child. How do the child be engaged, my lord? 5 hours, 6 hours, the child is there from 10 to 5. 7 to 8 hours, the child is with the father. How do the child, when earlier it was the mother used to be there, they used to play in the park. Now we do not know what he is doing. The child is also deprived of playing with the friends of his age in the weekend. Very well. He has a father. And how the father is engaging the child. What is happening there? They may produce photograph and say the child is very happy and what the child is doing. And this is what is happening when the child comes back home. Last time they did produce some photograph across the counter. Till date, we have not received any photograph of what they are trying to say. Now, my lord, all this, my lord, what we are trying to say is that when we have indicated to them what should be the meal time, what should be eaten, what should be done, well, discipline is something, my lord. Health of the child is one thing. If these are not inculcated at this age, then, my lord, we are not rearing the child how the child should be reared. In this era where all the advertisement everywhere, we are giving them everything. Swiggy food is being given every other day, my lord. On every weekend when the child is there. So very recently on July 14th also we have sent this email, my lord, as to what is this, how does he engage the child? Because he comes and tells what he does there. This should be a playtime on a weekend with his friends in the neighborhood, outside in the park, or he should get engaged in storytelling, writing something, inculcating values with the child. And when the child comes back on Sunday, my lord, he hits the bed early. As soon as he comes, has food and he hits the bed. Then he gets up in between at 6 o'clock, 6:30 if he sleeps. Yeah, 1 o'clock, 2 o'clock, he'll wake up. Then again, we have to put him again to sleep, that he takes rest and wake up at the proper time. It's again a big hassle to send him to school. Monday morning blues are always there with the child because of this disturbances, my lord. The child's eyes are strained and not to be playing on the screen, whether it is an iPad or in his phone.
Let him, will take, he's coming, it seems.
Please, ma'am.
We'll hear. Anyway, I've seen all those papers. Let him, just now you have given it to them.
Please, ma'am.
You don't require time to go through all that. Yes.
But basically what we are saying, my lord, there is also some judgments which I would want to rely upon, my lord, is that the child is too young at this age now to give overnight visitation rights. While we are not averse, rather that the child should not meet the father is not what we are saying. That from the beginning as a child, when the child was small, even breastfeeding, we've allowed the father to meet the child or other child to have contact with the both parents. That's the bottom line that the petitioner is, the respondent here and the mother is functioning from. What is the issue now, my lord, is the child is young at this age. Should we now give the child for overnight stay? Now, the longer period, my lord, without any protest, when your lordship took this issue in 26th March, my lord, we agreed. And the time is 10 to 5. Now, the child, he has the child for that long in the weekend. Now, my lord, after 1 or 2 years, when the child is 5, perhaps that would be a proper age, my lord. And therefore, my lord, I am relying upon the judgment of the take the this is for them.
Yes.
Lord, basically, my lord, the first judgment of the Honorable Supreme Court, my lord, 2012, it is the welfare of the, that I need not specify, my lord, your lordship is already following all these matters, my lord, that the welfare and interest and desire of the child to be paramount importance, that the ability of the means interested person, custody, availability of conducive and appropriate environment for the upbringing of the child, even if it is for a overnight visitation or in the weekend visitations, whether the environment should be conducive. That is what we are trying to highlight in this, the first citation, my lord, paragraph 14.
Yes.
Para 14. It's not the better right of either parent that would require adjudication or deciding the entitlement of the custody, the desire of the child coupled with availability of conducive and appropriate environment for upbringing together and the ability and means of the parents concerned to take care of the child. Ability and means is not, we are not questioning that, my lord. The environment now, does the child, the house that he is now taking the child, does it have an environment? Does he have any other person to assist him with the child, my lord? Even changing the nappies or the diaper is not done. At home, apart from him, nobody else is there. So when he gets a phone call or he is tired of monitoring the child or being with the child, or if he is engaged in his business activities, my lord, the child is on the screen time. Therefore, my lord, and the food habits, that is another thing which you are saying, environment is not conducive. In this second judgment, 2019, volume 7, last paragraph, my lord. Paragraph 37, my lord. A 4-year-old child, what was accommodated? Here also again the child visitation rights given to the parent, my lord. Lord, the 37th paragraph, the bottom 4 lines, my lord. Now, the first respondent shall ensure the comfort of the applicant 2 and 3 during the time of his stay in his house. After 3 months, applicant 2 and 3 shall have visited the child at the respondent's home from 10 a.m. to 4 p.m. on Saturdays and Sundays. After the child completes 4 years, applicant 2 and 3 may permit to take the child on every Saturday and Sunday from residence to the father office of the father from 11 a.m. to 5 p.m. And then he shall return the child back after 5 p.m. For any further modification, go to the family court. Now, my lord, what we are saying is, my lord, even the staggered, what your lordship is now granted, that should prevail for some time, or that practice should continue. And let there be, my lord, even when he takes the child, let him also have the same commitment, my lord, in feeding the child or making the child comfortable, and not to feed junk food. Disciplining, that is important, my lord. And the child rearing practices are different in both parents. Sometimes it may not be the same, but however, at least what we eat, how to food habits, this should be maintained, my lord. And so my respectful submission, my lord, is that the age is not right now, and child started going to play home only in November, October. And this is a transition. He's still getting used to, even in the school, my lord, initially it's 2 hours, 3 hours, then they increase it. So that is how your lordship is also permitted, that let that continue for
until the child is 5, my lord, and then they can make a proper application in the family court. That's my submission.
Yes, Mr.
My lord, I have one more judgment, my lord, sorry, Mr. Arun, one. The judgment which was relied upon by the petitioners, saying that the 3-year-old child, the Supreme Court had granted, that facts are completely different. There the father and the child, parent and the father lived together until 18 months, the child. So when the child was 18 months, separation happened. So the child and the father, he had reared the child. And his parents are also living with him. So these are the two factors which are to be distinguished in the judgment which they are relying upon, where they say a 3-year-old child, Supreme Court gave access to the child, overnight access.
Yes, Mr. That order sheet. You're referring to the order of this court? 11-3.
Initially, the invitation of the PR, second trial of the joint order. Having heard the word counsel on legal side, review the visible record. This court's modification of the orders passed by the family court ordered in 23/9/2022 has permitted the father to exercise the visitation rights on Saturday and Sunday of every week. And the duration is extended to 3 hours instead of 2 hours till the next date of the hearing. It is not in dispute that the father has been exercising said rights ever since orders are passed in this court. As per the orders passed in court below, the boy was sent to Hyderabad once. Considering the submission of grounds of both the parties, considering the fact that the boy is going to be 3 years old by 20th March 2024, this court is of the view some modification in the order to go to be required. So the father and child will spend some more time. Regarding overnight custody, considering the age of the child, and as all these years for only extended visitation rights for 3 hours each of Saturday and Sunday, straight away is not appropriate to grant overnight custody to the father. Therefore, watch it modified the order from the 10 to 5 on Saturday and Sunday. Thereafter, the matter came up before the watch it for 26th of March.
Yes. Yes.
Second paragraph, at 10 to 5 p.m., the first paragraph records the 10 to 5 visitation has been going on. No, sorry, first paragraph itself. This court order in 11-3 has permitted the father to exercise invitation right on the first, second, third Saturday and Sunday of every month, and on fourth Saturday and Sunday, the boy shall be with the mother. As the mother is also a working woman, and the invitation right between 10 a.m. to 5 p.m. on those days. Today, when the matter came up, both the counsels for the father and the mother submit that as per the order passed by this honorable court, visitation rights were exercised and the boy was considered. So as of 26th of March, there is absolutely no complaint from the mother that the father is not taking care of the child, he is feeding him junk food, he is showing him videos that are only watching electronic devices, not into emails. There is no such allegation. After your lordship, what passes the order, continuing the arrangement, thereafter the Lord, apprehending that there might be further extension leading to overnight custody, she starts writing emails. But my child also has written emails. They're both both graduates from very reputed institutions. So they are very good at their drafting skills.
No, more than your affidavits, their emails are running into
Many pages.
And a lot of patients, they have to type such long messages. Yes.
One is postgraduate from the US, one is from ISP Canada. So they're very, very clear about how they want to communicate and what they want to put on record.
So this is order dated 26/3/2024.
So thereafter, on 27/6, when the matter comes before your lordship, 27/6.
What is the complaint? 11-3.
What are the matters pending between the parties?
Restitution. And he has filed a restitution petition.
Husband filed restitution.
Husband has filed for restitution.
So
Transfer
how
to
many,
bank.
which year are there? Which year?
22. 21, the petitions are filed by the mother. He has filed, now it's transferred here from Hyderabad here, that is 22, that's filed, transferred here to bank.
That the father has taken apart, so he has not.
No, but one thing, no, I read their objections. One thing what he might have taken an apartment. But the thing is, anybody can understand. No, throughout the week, he's not there. He comes to Bangalore in a weekend, on a Friday. No, even in the house, there are somebody who can, like effectively take care of the hygiene, the dust and all which gets accumulated. That's a different aspect. No, the maid takes care. Now, for the child, if he is there the entire, the day or the night with you, the food and all definitely he can't be the how his routine goes on with the mother. How do you expect that it would go here?
Now he's not my brother saying like understand publishing he's not agreed by the 10 to 5 arrangement on Saturday and Sunday. The only objection is now to overnight custody of the father having child overnight with him on Saturday night. I understand. Ultimately the child has to come from you.
That's what.
We are looking at child welfare. Man, that's why
No, one more aspect. Now, what happens is Monday to Friday, he goes to school. The whole Saturday and Sunday, it's so happy for the father to spend time with him. But what about his time where he needs to have some good time with the friends or whatever it is? No, all the time, both of you can't sit opposite to the other and play. So that also, when you're interested for the welfare of the boy, it is about now the bonding of the father and the child is also important. But every week if it's happening, what about his time? Where is the relaxation for him?
The father engages not in the apartment at all. They are outdoor. He takes him to the visitation was happening in Kamal Park or Lal Park or any other park for almost 2 years. So the father and child do not have they know exactly how to engage each other. He brings toys for him, takes him to a park and keeps him to the park for him to ask him to have lunch together. But he's lived alone in the US for more than 6 years. So he cooks. It's not that he does not cook. This allegation of ordering food from outside, they're quite responsible, both parties. And both are very, very, very.
No, but one important aspect is, because he is staying with you for 1 or 2 days and you don't discipline him and he will be whatever he wants if you start giving, then it will be difficult for the mother to manage him the whole week.
I understand. That maybe not maybe completely incorrect. These allegations are these are only on email and all the emails.
No, let's forget about the allegations. I'm just asking what kind of a routine the boy has when he is with the mother. The same should continue here also. As far as routine means not on all aspects. The food, the habits, something is no. If the mother says it should not be done, the father should also not do it.
Children take advantage of.
That's what is happening. When they have choice of going here and there, then it's very difficult for the mother to take care of him the whole week.
Again, restart it. I understand. All I'm requesting is last petition request was kindly allow him to have his overnight custody only for 1 weekend. If the child has any difficulty, I will drop him back. My client here, his mother is coming from Hyderabad. She has not seen the child for more than 2 years.
So you have taken him to Hyderabad once. That's what you read the order.
She's suffering from sciatica. She's unable. She's not mobile. I have requested her to come to Bangalore to spend time with him this weekend. She is coming this weekend. She is coming this weekend. Let the grandmother also have the joy of spending time with her grandchild. No, the child has been taken to the Andamans, child has been taken to Delhi, child has been taken all over the country, not by the mother. I am only requesting that I spend 1 night with him in Bangalore so that I will call my mother. Not any difficulty, absolutely any difficulty.
So what about the other thing? When the court specifies the time, it has to be followed.
Absolutely.
That is one.
Yes.
And number two, every time she's all the emails that they filed shows that she's so many times she was kept waiting for minutes or hours together for giving the boy or what. That's what they stated. So.
We have to follow 7 to 8 minutes is the maximum she had. I will make sure that even that those 7 minutes she will not be going for. Ultimately, the child has to also get comfortable with the father.
No, I looked at the mails that are filed before the court. Whatever she is raising are all the genuine concern, which has to be addressed.
We will address.
And even there appears to be a genuine thing also because, no, a regular kitchen and a kitchen which operates on a weekend,
Yes.
it makes a difference. You know, whatever the boy eats and all, they're not available in the kitchen.
Yes.
So they have to get it from outside, which is not good for them. All these things are very important aspects.
But I also have record of receiving sending emails to her. I am preparing the food and send photographs to her of food the child is eating. Not with the allegation that it's Swiggy food or
Then do one thing every time the child is with you,
Yes.
where whatever he's eating
Yes,
on
video
his
call.
video call and also photo, you're cooking.
Yes.
That food he's eating might not be Swiggy food
Yes.
or with that you're cooking.
Yes.
Send a video
Very-
to her on every time you're cooking it.
No, in fact, the last email I written to her is, we need to partner as parents. We may have disputes as husband and wife before the court, but as parents, we should partner and bring our son together.
That is exactly what is required,
That is
unfortunately.
That is father's attitude, she has complaints against me, I have complaints against her, we will sort those differences out one way or another. But one of the child needs require.
So what is the arrangement as or no going on, please tell
10 to
me.
5, but not Saturday to Sunday.
No,
10
what is
o'clock
that?
he picks the child, my lord.
No. Every week what's
Every
happening?
Sat-
Every week,
3 Saturdays, 3 weekends, my lord, 1, 2 and 3.
1, 2.
First,
weekend.
second and third,
No, no.
Saturday,
Saturdays, he'll pick up the
10
child.
AM to 5 PM. He drops back at 5, 5:30, 5:45. Sometimes at 6.
So like he is there with you on Sunday.
Sunday it's with him again.
10 to
10
5.
o'clock, 10 o'clock, morning till evening he's with the child, with the father. And he comes back, as soon as he comes back, he eats food and goes to sleep. That is his stress, that is his tiredness.
Please with me, his school is really 12 o'clock in the afternoon every day. The mother actually works from home. She has company every single day. So all I'm saying is 1 week in the Lord, since he's spending 10 to 5 with me on Saturday and Sunday, and I come all the way from Hyderabad, 1,500 kilometers both way I drive and come every week. I have not missed not a single week in the last 2.5 years at least. Not one single week. But I'm dedicated to spending time with my son, building a strong bond with him, and also to take care of his health. The Lordship, I record my submission, Lord, no junk food, no phone time on electronic devices.
And she says that no, the complaint is nappies are also not changed.
He's 3 years old, he's no longer a diaper. He's no longer a diaper.
It's still there, it's still being weaned away.
He's bottle fed. He's having milk with the bottle.
Not the claim before the family court was until 2 years he was being breastfed, and therefore
course.
cannot be given custody.
Of course. They were still breastfeeded, they were even till the time the child started going to the play home, my lord. At 3.5, that is what the gynecologist even advised, as long as you can. Feed the child.
No, there is no difficulty in that.
We will file an affidavit board that nutritious food will be given, that no device time will be, will not be on devices, unless of course we have to speak on video with his mother or something, or if he wants to watch a movie or, so kids like watching cartoons.
That's a whole difficulty. Now you have to follow the routine what the mother is following. If he's like, if there is a time for him for the screen time, sometimes in like, so whatever it is, you have to find out and do it. No, why don't the mother give them a schedule of what the boy, every day goes through?
We have given him the schedule, what is the timing, and that is
If
the
you
email,
have
my lord,
that-
page 19. What food is being fed is also there. In the email, we have said that as early as 11th March when this came. And even this, my lord, the day one day he went overnight, that's where, the visitation is extended period, from 3 hours to extended period. First visitation, your lordship has noted down. The allegations that we have now made our built up, all this is not correct. It happened the previous day and the next day we were here.
No, it is not allegations. You have placed before the court what are the difficulties in the visitation. No, just because there are difficulties in the visitation, that means that doesn't mean that we have to stop it. Now we have to give him an opportunity to rectify that. If he is not doing it, then we will take a call on
Very
that, what to be done.
Very good.
And even I went to her yesterday, I have clarified everything.
Yes.
If you remember one, I will give my copy. I have one copy. I have clarified the last email, 17th of July. I have clarified everything in my previous mail. I have politely and amicably sought your cooperation for Neil's sake. Instead, I received email with allegations intended for court use this Thursday. Non-existent problems cannot be solved. I have been striving to keep you happy, but now we are venturing into areas where there are no problems. You seem to be purely operating under the cloud of litigation evident in your behavior, email tone, fonts, and your related lies in court. One of which is that not once have I allowed you to speak with Neil when he was with me. Is this the kind of litigation you wish to pursue? Please think of how Neil might view these cringeworthy allegations once he grows up and had access in the digital age to all those concocted stories. Regarding Neil, constant questioning of Neil after his visits will likely lead him to lie to please you. I have written to you in detail about not interrogating him. Psychologically, it will harm him. Was Neil taken to an eye doctor? Can you share the diagnosis? This is the 9th time I've requested his health records. I have one West with me. I have never lost.
And one more thing is, why is he going to the school? Why is the father going to the school?
No, that week when he did not have visitation, that week he was here, hearing on the Thursday of that day he went.
Let him not go. Let him not go. Why should he go to the school?
No, the child asked him when are you coming, because all other parents come to pick up children. The child asked him when are you coming.
But unfortunately for him, that option is not there in the light of the dispute between both of them. When both of them are okay, then they can. And that too also, like if both of them want to go together and go and come back. But not like this. Unnecessarily it ruptures and unnecessarily it gives rise to another IA, which is pending before the court.
Family court. He tried to take the child from the school, my lord. And that's the reason why we had to approach the family.
Mother has no knowledge about it.
Before she could reach the school, he wanted to pick the child from school and go.
I'm sorry.
That's the reason why we are fighting.
There is no way these kind of allegations can be either be proved or these kind of allegations are made. When the court order saying.
Because when the court order says that this is between this and this, and above that, if he takes it, it's like something needs to be considered.
That's the application here, my lord. I'm reading from the application. Yes.
No, the lordship, the record managing, I've never taken him from the school outside. I've gone to meet him after school is over for some time, for a few minutes. 26th of March, the military plant has no allegations against me. After the time is extended, all these allegations start.
My lord, that was only a day before, then matter came up before your lordships again, my lord, on 26/3. Previous night, the previous weekend, the child, first one visitation, then the lordship posted this matter. That day, my lord, we are yet to stabilize. It's over. It's not that we are creating something. On that day, we had these allegations. When the child comes and tells us, I do not have to ask. I do not interrogate the child at all, Mel. That's what the petitioner says. The child comes out and says, what are his problems? That's usually the children, even in school, what they happen to come and tell the parent what's happening. So therefore, my lord, this is not the right age, my lord. Would have filed an application for modifying or reducing the time, which is what she's also asking. But we did not do that, my lord.
What was the trial court granted?
Trial court had granted 2 hours.
2 hours. On
Saturday only. It was.
I think now this order that is granted by the court is much than what has been granted by the court. So why don't you for some time enjoy this instead of, adding one after the other? No, every week you're having it. It's happy. Like, in fact, the whole day he's with you. 8 o'clock, generally the child sleeps. So on a Saturday was till that time. And when it comes to a Friday, it is like 5 o'clock because he has to take care of the other things next day. I think it don't require to be changed at this point of time.
One night, this is undertaking an accident will place on record.
That you will not come up with application for overnight custody.
No, that we will not have the child uncomfortable.
No, it's not that.
Because I come all the way.
No. What we'll do is, like, subject to what she says also, let this order, what is passed by this court, will make it absolute and close this writ petition. And only for this, you said some Saturday, like his mother is coming, only on that day will grant. And remaining will confirm this order and we can close
This
it.
order be confirmed, my lord. Let him make an appropriate application at the appropriate time when the child is old enough, my lord. At this moment, my request, my lord,
No, only.
Lord,
because
if
this
the
week-
mother is coming, let her come and stay with me, my lord. That's one request I would say. That secondly, my lord, the child is there from morning till evening.
When a 498 complaint is pending between the
Lord,
daughter-in-law.
The mother is there, my lord, the morning till evening, the child is with the mother and the father. Evening, let him come back to my home, to the mother's home, my lord. And when the child is at appropriate age, let that order be passed, not at this point of time.
When is she coming?
This week.
And I'll also record that you are not pressing for the overnight.
Increasing allegation, including the mother is given the access card to school. Mother is given the card to go to school and visit the child. If the access card given to the mother.
For the parent-teacher meeting, my lord, not otherwise to meet the child on a regular basis on the outside on the street, my lord.
Anyhow, no, the best interest of both the parties and the child would be in adhering to some rules and regulations, which would make things smooth.
No, there is one thing, what she said, no. Until the father not ample time with the child or every weekend. Like people at least 1 weekend in the month, let the child stay overnight. And thereafter, depending on his comfort, we make an application to the family.
When the child sleeps at 8 o'clock, how does it matter whether you have a overnight custody or not?
The allegation is, he's very tired. He does not, so, I will have the pleasure of, my son sleeping next to me. I've never had that pleasure, since the time he was 1 month.
So the
So
child
stay away
sleeps,
from me.
the child sleeps in the afternoon also.
The night, the thing is, I don't understand, for a parent, when the child wakes up in the morning, to have that time with the child, to see him wake up.
Unfortunately, with all these disputes with the wife, your child unfortunately can't have it right now. No, what we can do is, if you say that you will not insist for a overnight visitation, right, and will remand the matter to the court. If on that condition, your client is also here, will grant a overnight custody when your mother is here, and remaining things we will close it.
The family could reconsider the application for overnight. Family could reconsider. Here I will not present for it if I'm given visitation.
No, GNWC of which year?
21.
Where is this? What is the stage of it now?
Applications, evidence, matter should go
What
for
is
evidence.
happening here?
The application, they keep filing every day one application, the matter goes on around their applications, well.
Two issues. Now, one thing is, so, Govindraj, now the thing is, one, this the court will confirm and leave it as it is. Keeping it open to the parties to move an appropriate application. Whenever, that I don't have to say, that as far as this is concerned, this will be, the final arrangement dated so and so would be made absolute, and I'll close the writ petition. That is one. Second is, if you want a overnight custody on that day, when the petitioner's mother is coming to Bangalore, if that day the order is passed, that I have to record that only on that day you're seeking, and further you will not ask for the overnight custody.
One more issue. Again. Concern about his mother can't have every time because she has sciatica. She never come to the last 3 years. She's not come even once. Only this weekend I called her a special 88th star birthday. They celebrate some star. So he wanted her to celebrate the birthday with the grandchild. But my father is no more. Many years. But if I want to take a child to Hyderabad, not during vacation or anything, overnight will come out. Will come out.
Then we'll close the writ petition with that
Very well.
one day on that day when this mother is coming. And the remaining, I'll leave it to the court below.
Lord, the mother's birthday is in December, my lord, not in this month.
Star-
Star, but the 6 months ahead, my lord, certainly not, my lord. Just in few weeks, my lord, star birthday can't come 6 months in advance. Earlier application was mother's birthday is in December and they filed that application in December. And now
Generally,
birthday,
there won't be that much difference between
star birthday
birthday
can't be
and-
so much, my lord. My lord, your lordship may confirm this order, my lord, with liberty, whatever want to move, and the child is appropriate age.
Look, I have the liberty not to request the family not to consider my request for overnight.
Give
After this weekend.
give that writ petition. Agreed with the order. With the order passed by the family court in IA number 4 in GNWC 3 of 2022 dated 28/3/2022. The father is before this court. The family court had granted visitation rights of the minor child on first and third Saturday of every month from 11 a.m. to 1 p.m. at common place. After holding discussions with the mother, when this matter came up before this court on 11/3/2024, this court had has permitted the father to exercise the visitation rights on first, second, and third Saturday and Sunday of every month, and on fourth Saturday and Sunday. The boy shall be with the mother, as a mother is also a working woman. And the court has also observed that this is a temporary arrangement. And on 16th, 17th, 23rd, and 24th of March 2024, the visitation rights are between 10 a.m. to 5 p.m. And this court has specifically observed that during the visitation, the mother shall be permitted to have contact with the child. And if the child wants to talk to the mother, father should make the necessary arrangement. It is also stated that the father has taken a premises which is very near to the place where the child and mother are residing. The father is permitted to pick up the child and drop the child by 5 p.m. as per the orders of the court. And the earlier order of video call on Tuesday and Thursday for 15 minutes at 7:30 p.m. shall continue. Thereafter, another order came to be passed on 26/3/2024. Then, as the boy's birthday was on 30/3/2024, on that day from 11 to 2 p.m., the father can exercise the visitation rights. In continuation of the earlier order on first, second, and third Saturday and Sunday between 10 a.m. to 5 p.m., the visitation was continued. By order dated 27/6/2024, the court has granted the visitation on Friday, 28/6/2024, between 5 p.m. to 8 p.m. and on Sunday, that is on 30/6/2024, between 10 a.m. to 5 p.m. Then the court has observed that with regard to the overnight custody, whatever the objections the mother has, she shall come up with her objections. When the matter comes up on the next occasion, the orders will be passed considering the case of both the parties. Now objections are filed by the mother stating that the father is feeding the boy with the junk food.
So that will be over at one weekend. But, and since it's been 2.5 years since the family court passed the order, March 2022. I may be permitted to file a fresh application regarding overnight and other things. Child also started school work for vacation custody.
What did you?
So the objection is the family court work.
That the father is feeding the junk food and is permitted to watch, is having a lot of screen time. And with regard to the hygiene also, certain concerns were raised. It is submitted that the boy is feeling very tired, and the moment he comes on Saturday, Sunday, he's sleeping. It is also stated that the father is not adhering to the time stipulated by this court. The mother is not receiving the calls as per the order passed by this court. And also, the father has visited the school. And even before the mother reached the school, he tried to take the boy. That's what she said. No, that time he tried to take the boy from the school. It is submitted that the boy is of a tender age, and this is not the stage where a overnight custody can be granted. He was never with the overnight custody can be granted all through. He was with the mother. Now staying for this long time in the weekends is making a lot of difference. And the manner in which he has been brought up by the mother, and in the weekends, how he has been taken care of is not the same. And this is also making a lot of difference in bringing up the boy. Then counsel submits that at this age, he cannot be permitted to have the father can't have an overnight custody of the boy. Next para. Then counsel appearing for the petitioner father had denied all the said denied the allegations made by the wife and submits that he has been taking care of the boy. He has been given the properly home cooked food, and in fact, he is ready to take care of the boy the manner in which the wife is taking care of the remaining 5 days. And he'll also, they have already been taking, and they'll make sure that whatever the routine that is followed while the boy is with the mother, the same would be followed by the father. It is submitted that in fact, the mother had given the access card to go to the school. So question of the father going without the notice of the mother is to not arise. It is submitted that the father of the grandmother, the paternal grandmother of the boy is coming to Bangalore on 20th. And it's been 3 years that as she is having some ailments, she is not in a position to travel. And counsel submits that the boy is comfortable with the father and he needs to have a overnight custody of the boy, and particularly on 20th when the grandmother is coming to Bangalore. In response to that, land counsel for the respondent submits that they said if they want overnight custody and an appropriate application needs to be filed before the court, and at this point of time, considering the welfare of the child, the overnight custody cannot be granted to the father. Next, having heard the learned counsels on either side, there is the material on record. By virtue of the order passed by this court, the father is meeting the child on about 3 weeks, on all first, second, and third Saturday and Sunday. Earlier, the boy was taken to Hyderabad on along with the mother.
Yes.
Mother's landing. He's going to be here.
No, no, she went, the mother of the
Talking
child,
about earlier,
mother of the
was
child
taken
went
to
to.
mother, taken to Hyderabad, and the mother also accompanied the boy. This court had carefully considered the submissions of both the parties and also the objections that are filed. The objections, some of the objections that are filed by the husband, by the wife.
They were not, there's no opportunity for the rebut, therefore, I mean,
No, in the end of it, some of the objections that are raised, without going into the disputed questions, but the concerns that are raised are genuine from the mother. Some of the objections are raised with the mother or genuine with regard to the sleeping pattern, about the screen time, about the hygiene, food. According to the father, he is adhering to the same, and he has been giving the food as he is having in the house. The father ought not to have gone to the school when he was not having the visitation rights and without the knowledge of the mother. From hereafter, without an order from the court and without any order from the court, the father shall not go to the school. If any permission that is required, he can move an appropriate application before the court. Huh?
I will not go to school except on days all parents.
Except on parent teachers meeting, on other days, he should not go to the school. If he requires any permission, he has to obtain the permission of the court by filing an appropriate petition before the court. Considering all these aspects and taking into consideration the welfare of the boy, this court is proposing to dispose of this writ petition in the following manner. 1, the father shall continue to have the visitation rights on 1st, 2nd, 3rd Saturday and Sunday. On the Saturday, he shall, what was the time?
10 AM to 5 PM.
On Saturday, 10 AM to, no, on Saturday it is 10 to 8, I think.
10 to 5. 10 to
On Saturday, 10 to 5. And on a Sunday?
Sunday also it's 10 to 5, but if you could send the child early, it would be good so that he can get
Because
into
on a Sunday, what will happen is.
next
like,
day morning.
To get, on the Saturday is with you, if Sunday is with you, anyhow, he'll sleep, as she said, after 5 o'clock, he'll be tired, change of place. So why not on a Saturday little early? 4 o'clock? Sunday.
Saturday, we get to board.
He goes to school.
Only reason is it's not a-
On Saturday, from 10 o'clock to 6 o'clock, and on a Sunday, from 10 o'clock to 4 o'clock. 4 o'clock, next number 2. Either the father shall pick up the child on time and shall drop the child on time. And both the father and mother shall adhere to these timelines strictly. Next, whether the child asks or not, while the boy is with the father, he shall make sure that he shall, the boys, no, so that unnecessary confusion won't be there. At least 2 times in the day, while he was.
No, the better call 6 times, but instead of considering kind of allegations coming against me, but better call it 6 times.
No, problem is your phone is not reachable. So that's why let him know, give the phone to the boy, he'll call. So 2 times while the boy was, at least 2 times, when the boy is with the mother, the father shall see that, a call is, that he speaks with the mother. Next, the food that the boy is eating, at all times should be, the details of the same shall be shared to the mother. The details shall be shared to the mother. Next, the junk food, which is not good for the boy, shall not be given by the father. The screen time, if in the school, as per why he never watches TV in their house?
There's no TV in their house, my lord.
Not in their house. In your house.
Half an hour or 10 minutes, it's a baby. That's what it, my lord, the small child, my lord, what is
No,
the
no, it's okay. The court is not saying that. Something you should tell him.
minimum, my lord, it's saying whatever cartoon if he watches also, it's a minimum time, my lord, and not.
It should
No,
not
that's
be
correct.
left with this, left with the gadgets more for a longer time.
Not more than 10-15 minutes at this moment, at this age, my lord, no.
Micromanaging, Lord, please. They want to micromanage everything. Lord, he, my son also. I also
You
have-
know, what will happen is, it's not about your son or her son. Problem is, no, because he's staying for that only 2 days, you just want to pamper him. That's what happens.
Santa Claus father.
It is not that
Claus
you
father.
want to spoil him. What will happen is that pampering will be difficult for the next 5 days for her to, that's what, longer time. Longer time. The school, except on the parent teachers meeting, without the prior permission of the court, the father shall not go to the What is that? With
School day, my lord. School day and parent
Ah,
teachers day. School day and parent teachers day.
School days. No, on any function in the school, and on parent teachers, any function in the school and on a parent teacher meeting.
Not on a daily basis, but there are certain days parents to come and interact.
Wherever there is an interaction for the parent.
No such time is fixed, my lord. Children come from their respective parents home, where will the parent teacher interactions will be there, my lord?
No, we'll say wherever there is wherever as per the school permits, any parent interaction or something is there, on all those days, wherever the parents can be present.
Days, such functions, my lord. The other days, he'll say this is the time that's permitted, he will just barge in.
Parent, what will happen is unnecessarily another dispute between the parties. When there is an interaction between the parents and the school and the parents, when there is an interaction and where the parents are invited on any occasion,
that is
then
better.
only the husband, the father can go to the school. On other occasions, if for any reason, if he has to move the court, and on a prior, on order from the court, he is permitted to visit. Everything is covered? That is.
But on the 5th week, there are 3 weeks, Saturday with him and Sunday, 1 day each, my lord. Let him come on a
If
Saturday.
and all in any month, if there is a 5th weekend, on that Saturday would
Saturday
be to
with
the
the father
father,
and
with the
Sunday
same
with them.
timings of 10 to 6. And the other day would be
10
to
to
the
5
month. No, on a Saturday it is 10 to 6 now.
This will be only 10 to 5, next will be.
Then that is the one. No. As far as the overnight custody of the child is concerned, the father is at liberty to move an appropriate application before the court. Overnight custody and vacation, he is at liberty to move the court. Next, on 20th Saturday, the father can have the overnight. Then what will happen is
Not
if you
overnight, my lord, not overnight. Let him have the child, no, my lord, that was not at all agreed.
No.
10 to 6, let the child stay until 6 o'clock, let the child be
Then
sent back.
what can happen is, if you have a overnight custody on Saturday, then that Saturday, the Sunday, no visitation.
I'll welcome back with Sunday afternoon.
No, my lord.
On a
No, my lord.
Saturday,
After lunch.
Not overnight, my lord.
then on Saturday, the 20th of,
But the child, let it come back even late, my lord. 7 o'clock, 8 o'clock, let the child come back,
On
not
Sat-
overnight, my lord.
on then have that.
But when my mother's coming only on Saturday evening.
She's coming on?
Saturday evening, 20th evening she's coming.
Then on Saturday, on 20th Saturday.
Sunday morning, let him have the child, my lord. Let him, Sunday morning, the child will be there with him.
The child shall be picked up from the mother at 6 o'clock in the evening and shall drop back the child on Sunday at 12 o'clock.
After lunch, one period.
Lord, not overnight, my lord. Let the child come back on Saturday. Lord, she is coming.
12 o'clock.
But
No,
she's
in the
coming.
contentions, the land counsel with the respondent has stated that a overnight custody cannot be given even on 20th, when the grandmother is coming. As the grandmother is there, who can take care of the child, the overnight also, and considering the fact that the boy is spending the time with the father from several weekends as per the order passed by this court. And also, this is not an arrangement that is made on a regular basis, that as the grandmother is coming to Bangalore, this court deems it appropriate to grant a overnight custody only on that day. On Saturday, coming back to this, he shall be brought back at home by 12 o'clock.
But in case the child cries, he should be sent back. Well, that's what the undertaking will.
Overnight, 1 minute during the overnight stay, if at any point of time the child is not comfortable, that should be immediately brought to the notice of the mother, and he should be he should be sent back to the mother.
My lord, this order should not influence.
This interim arrangement only comes, 1 minute, this interim. No, that's what I said. This interim arrangement with regard to the overnight stay of the boy on 20th Saturday is only considering that the grandmother is coming to, 1 minute, coming to Bangalore, and this should not be, the court shall decide the application, if at all any file, independently, without being notwithstanding the fact that an order is passed by this court granting overnight custody. Last, the father has not filed any objections to the has not filed any reply to the objections filed by the mother. As such, he is at liberty. Which is filed today, he is at liberty to file his, he is at liberty to raise all his objections in an appropriate petition.
Last, I will not make you. But apparently, other sister and sister children are coming. So after lunch, I will drop him back around
2 o'clock.
So fourth weekend, the fourth weekend, it doesn't have any invitation. Document given Monday 4 to 6. Come on, only for this 2 hours.
What is that? I didn't get.
It's on the fourth weekend since the mother has Saturday, Sunday. The lordship order dated 26/3 gives the father on fourth Monday an extra visitation from 4 to 6 p.m. It's it. He comes from Hyderabad only for those 2 hours to spend time with his son. He doesn't want to give 15 days gap to his small child.
He has a longer date weekend, my lord. Let the child be on its own, my lord, that day.
Monday?
On fourth weekend, Lord.
On fourth,
Monday.
After the fourth Sunday, the ensuing Monday, between 4 and 6, the father.
Instead of Monday, lordship have on Tuesday or Wednesday.
He comes from Hyderabad.
He has to go back. No, he'll go back.
He's not employed anywhere else, my lord. It's just as doing his own business. She will have a hectic time, my lord, again.
No, like that 4
Instead of, that is why we're making the request, my lord. Instead of Monday, let it come on Tuesday, my lord. Let him meet the child on Tuesday.
But he's there on Sunday here.
Sunday is not there. He comes only to meet the child.
On Monday he comes.
He comes to meet the child on Monday.
No, Monday on a fourth.
Fourth weekend is for her.
Fourth weekend is
He's
not
not
there.
Comes
No, I can understand if you're coming on a Saturday, Sunday, and a continuation you're asking. No, it's not that. No, on a Sunday, anyhow, instead of coming on a Sunday, come on a Monday.
Monday 4 to 6 $.
No, come on a Monday or Tuesday. They want it on Tuesday. No, everything. No.
I have my work also. The weekends, Saturday, Friday.
Monday is a working day.
Monday is working day. Monday I can take off. Monday if I have to come, Monday night, I have to leave Monday afternoon. Monday work goes and Tuesday.
Lord, as it is.
No. Monday night you come Bangalore, Hyderabad to Bangalore is you come by morning. So Tuesday you can exercise. Tuesday on that, after that fourth Sunday, the ensuing Tuesday, he can we exercise the visitation rights between 4 to 6.
Again, Friday I have to come back.
No?
Again, Friday I have to come back. Tuesday and Wednesday I have to go back. Friday I have to come back. Therefore, Monday.
Monday. Monday, 4 to 6.
But Monday, my lord, with all this, she's losing her job. She's unable to even retain the job, my lord, because she can't even, the mother, because of all these tensions here and can't go take up jobs outside.
Why don't she settle all this?
We are trying that there's no
Have you
amicable
come out with any proposal?
mediations were there. It was there for a longer period.
Yes,
Let that be on
Mr.
a Tuesday, my
Govinda,
lord,
is
not
there
on a
any scope
Monday.
for settlement?
Mondays are hectic for a Let it be on a Tuesday. We are ready to sit and discuss, my lord. We are not aversive for any amicable resolution at all. Let it be on a Tuesday, my lord. Monday is.
That is only on 1 week.
One weekend.
Tuesday.
That's it. That's her job. You are doing your own business and she is employed elsewhere.
If I come on Monday, see him on Tuesday, I have to go back to Wednesday.
No, why don't you skip that week and come the next week?
15 days, he's not left 15 days gap from the child, time is 6 months old. Every single week he has been in bank.
No,
He
it's a
talks to
case
the child
where
on video.
Now, everything what your client has been asking has been, you had it. So now I think you should not insist for this.
And the wage arrangements going on.
No, I don't know. She said that
Difficulty.
she has some, she's losing the job like or
Exactly.
something.
The father should be 3 days of work. That's the only intent.
He has his own business, my lord. They're not employed like us.
Yes,
Tuesday.
ensuing Monday between 4 and 6. Yes, next one.
My request for a Tuesday, my lord, and let her not lose her job. She
Why?
is.
No, 4 to 6 for him to
Mondays are
exercise.
hectic, my lord. She has clientele all over the world. She's
No,
working
no,
on
no.
Amazon.
Why? No, she doesn't have to. He'll go and pick the child. In the house, his mother is there. Her mother is there. Why should
Somebody
she?
has to keep the child ready, go down, pick the child, come up, all this. On a Tuesday, my lord,
No,
it should
maid
not
is
trouble
there.
him in any
No,
manner,
no,
my lord.
maid is there, mother is there. No, I can understand it's a genuine request. If something, because she doesn't, if I can understand, she has to go and drop the child. It's not that. He will come and pick, mother is there, servant is there.
He meets the child on twice a week. He meets on video access. He has. She has to
So
come
that
down to
video
drop.
access, the video access is between what?
2 weeks to a Tuesday and Thursday, 15 minutes. That's the time. That
Tuesday and Thursday, oh?
every week.
On every
Video
week, the father can speak to the child.
Lord, best
On a-
to do away with that Monday or they have it on a Tuesday, my lord. That's my request, my lord. Humble request.
Settlement go on. They're going to settle in. Look, all this will pave the way for settlement. Even this is going to-
As earlier directed by the court, Monday and Tuesday between what time?
Monday.
Tuesday and Thursday, 7:30.
Tuesday and
Or
Thursday.
Tuesday.
Tuesday and
Tuesday
And Thursday.
Thursday. He has a video access.
Tuesday and Thursday, he can have the video access to the boy between.
7:30.
15 minutes, 15 minutes, my lord, done at 7:15 to 7:30.
7:15 to 7:30. Yes.
He has this, my lord. Therefore, we are saying that Monday can be avoided, can have it on another day, my lord. Monday, she is in the more.
When he has, it is on Tuesday and Thursday, no, this video call.
Video call.
Hmm.
He can meet the child on that weekend. Instead of coming, he can meet the child online, my lord. So or instead of online, he can meet the child personally.
Yes.
Monday, my lord, may I request, my lord, Monday to avoid, my lord, because she is in a distress regarding her job.
No, how that time, no, if you
Her
can convince the
passport, my
court-
lord, he did not sign the passport. No, she cannot travel abroad. And her job, travel abroad because breastfeeding child, she had to
No,
take the
that-
child.
those are all different aspects. Now you say that if there is a visitation on a Monday, it would somewhat,
It is
like.
culminating, or everything is culminating into that, my lord. All this dispute and this visitation rights arrangements are, her inability to travel is one thing which is impacting on her job. And therefore, let this not be added.
Why the husband will not, why her passport can't be?
There is an order for this honorable court to renew, but he did not even come to sign, not to renew, to get the passport. He did not sign, my lord. There's contempt
Passport of the
petition.
child.
Passport for the child, he did not.
No, but like how it will hamper her
Lord,
career.
she was breastfeeding the child. She can't leave the child. She had to take the child whenever she was going.
She can have it.
He did not sign. The consent was not given.
Not for the child. I'm talking about the.
She can
mother.
travel, but then she had to take the child along with her. And he
Where is
did
that?
not sign. He did not sign. He did, though there is a direction of the honorable court, he did not sign. 8-10 months ago, contempt petition was avoided for all these days. Even last time here, it threatened the police when the police came to say.
they want to talk settlement and they want to talk about contempt and.
No, the reason why we are saying is how it's going to impact on a job. Everything is being granted, now you say all this.
44, Balraj KM for petitioner.
Yes. Then counsel the permit take out notice, there shall be said. Where is the report? Report. Report not filed. What is report not filed? I think something thoroughly wrong with the registry. Call the registrar judicial to come to the chamber. What is happening every time? Look at the order. Open that order. I thought that I'm asking where is the report?
That report of
Do that. This court by order dated 8/7/2024 has directed the first additional principal judge family court Bangalore to submit a report. And the report shall be placed before this court within a week. It appears that the order is not communicated to the learned judge. Registrar judicial is directed to communicate the same to the learned judge. And the report shall be placed before this court by 29th. Post this matter on 29th. Stay interim order granted earlier is extended till then.
Bill number 45. Awaiting notice in respect of.
Post after service of notice.
And for the
Bill
respondent.
number 46.
Yes.
46, non-furnishing of PF and cover to issue notice for first time.
No representation. No representation. Post for discussion on 25th.
Bill
Yes,
number
47.
47,
Await service of notice. Post after service of notice. Then let the notice serve. Post after service of notice. Next.
Bill number 48.
I take notice to the respondent, my lords. Someone is not yet served on me. Kindly. Someone is not served on me, my lords.
You are appearing now.
Yes, my
What
lords.
is your name?
Ashok Patil, my lords.
Then counsel Mr. Ashok Patil submits that he has instructions to file wakalat. Post this matter on, copies are served?
No, my lords.
So copy. So the post this matter on August 13th. Then counsel the petition shall serve the copy on the counsel appearing to the respondent.
Bill number 49.
Interim order earlier granted is extended till then. Yes.
49.
Await service of notice in respect of respondent, non-filing of memo for having taken out notice on advocate for respondent. I am talking about you. Have you taken out notice?
Bill number 49, sir.
No, next order is there. This court had directed you to take out notice on the Have you taken out? You are for the petition or respondent? I am asking petition only. Post this matter on 27th of August. Yes.
Serial number 50, my lord. The matter was to be taken up in chambers at 5, but it was listed at 2 o'clock.
I had instructed my party to come at 5 o'clock, but because of the
No, that is, I think,
the cause list says 2 o'clock, the order sheet said 5.
5. What happens is there are 3 matters today.
I thought so.
So that's how they were adjusted.
My
I
apologies.
thought that might be the reason. Now the client is there.
No, not now. But I told her not to come because she has to come from Whitefield.
Anyhow, like the
The matter has been adjourned to Monday.
22nd. She's coming on 22nd.
If your lordship orders, she'll come on 22nd.
But again, we can't, she should come.
She'll come.
See, when is, no. Do we have any matter on 22nd? Then let it be there, this also on 22nd morning, that afternoon matter on 22nd in the chambers instead of court.
22nd chambers in the afternoon.
Chambers.
I'm obliged.
Permission to submit at serial number 52.
Oh.
Your ladyship, we have filed our counter. I will serve the copy on the other side and your ladyship is pleased to meet the child in chambers at 5.
No, it's coming up in the chamber.
Yes, but this can I serve and this should be.
Whatever it is, you just give me like the matter. I will see when it comes.
Yes.
Wednesday. And in chambers ಅಂತ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ.